कार में. Good morning, everyone. Shall we start, sir?
Yes, we can start.
Manchi, sir, shall we start?
It's already 9:36.
Sir, shall we start now?
Yes.
Good morning, everyone. I welcome you all to the workshop on the topic knowledge session of PUFE transactions under IBC. Today we have with us Mr. Raghuram Manchi and Mr. Prakul Thadi as faculty. The first session will be taken by Mr. Raghuram Manchi. Let me introduce Raghuram sir briefly. Sir is a qualified CFA, CAIIB and registered insolvency professional. He is a career banker with experience in all areas of banking, specifically in credit appraisal and monitoring of corporate advances. He has experience in retail banking and branch banking, also as a branch head of several branches. He was as VP in Axis Bank and retired in 2019. He authored a book, Limited Insolvency Exam MCQ and Case Analysis, published by Taxman Publications Private Limited. He has also published articles related to banking and insolvency resolution. Now over to you, sir. Please start the session.
Thank you, ma'am. Good morning to all of you, colleagues, friends, seniors. I'd like to start by wishing all of you a happy new year and wishing you great success in your profession in this year, and let all your assignments go smoothly. And on this note, I would like to start this session. Basically, this is a knowledge session, and on the matter of PUFE transactions. Most of us, or all of us, probably are familiar with this concept. And then since we are doing continuous professional education, and it is a good time to revise the concepts and then try to share our experiences. So basically, I'll try to share the screen now. I hope the screen is visible to all of you. Everybody could see the screen?
Yes, sir, screen is visible.
Yeah. So this is a knowledge session on PUFE transactions under IBC. Now, basically, where do these PUFE transactions come in? That is what the first thing we should understand. Because when a CIRP is admitted and the order is issued by the NCLT, the first focus of the IRP would be on how to get the thing going. Because IRP would be busy with the publication of an announcement. Public announcement is the first thing, which it has to be done in 3 days. And then within 7 days, some claims have to be, 14 days, claims have to be collected. And then we start busy taking charge of the corporate debtor. And all these things follow. And then it becomes like a roller coaster thing, because the IRP would not know the unit, and then first he has to see, find the office, go to there, meet the people, suspended directors, employees, all these things are there, and then they have to understand the business. Maybe the industry itself is new to him, but then all these things. So the focus basically would be on getting the CAIRP on rails. This being the case, so how this PUFE is going to be very material, because the general tendency would be to think that, okay, now we have 75 days, so we can do it later. But today we are going to discuss what is the importance of PUFE, especially in the beginning of the CAIRP, what is called, like, when you start it, what exactly we need to see. Because once you have this clear understanding, the moment you step into CAIRP, the CD's office, you'll start observing things, what is required, what could be wrong, and all that. So now this agenda of this session will be in following points. First, we'll have an overview and relevance of PUFE transactions, and then what are the different types of PUFE transactions. And then we'll pass on to how to identify the potential threats and PUFE transactions through financial analysis. Because that will help us, because we have certain data with us, and based on that, the RP or IRP is supposed to form an opinion. And then once we have a basic idea, then we have to appoint a transaction auditor or a forensic audit. All these things we'll see. In the afternoon session, there will be other things, how to file an application and all that my colleague will be taking. So this is the basic agenda. And then, so first let me start with, basically I said PUFE, though we are busy with the CAIRP and meeting the creditors, forming the constitution of the COC and all that, parallelly on the next track, we should be observing what is the relevance of PUFE transactions. We should be seeing how it is going to help us. Now, it is very common to see erosion of value of the assets of the corporator once the insolvency process starts. If you compare the value of the enterprise, maybe 1 year before the CAIRP, and once the CAIRP starts, and after 6 or 7 months or 1 year of the CAIRP, you see there will be a gradual erosion of the value. Then the part, how this value, because even the resolution applicant who is coming in, who is going to bid for a much lower value than the original value of the enterprise. So a part of the erosion would be explained by the PUFE transaction. So once you understand what are the different transactions which have taken place in the twilight period, meaning just before the insolvency period has started, before that, maybe 1 year or 1.5 years, 2 years before the ICD, before the start of the CAIRP, the twilight period, what the directors have done, what the promoters, what the people, what exactly has happened. This could be the reason why it has become insolvent. Now, one of the objectives of CAIRP is maximization of the value of the assets. So if you want to do maximization of the assets, first, individually, of course, each creditor will be there, a banker would be there, he has some securities which are mortgaged to him, but he can realize, but only that particular city is security he can focus. But as a collective effort, when RP leads in detecting the PUFE transactions and filing an avoidance application, when the collective action facilitates maximization of the value of the assets. And one more important thing is that if these PUFE transactions are very clearly seen, it will act as a deterrent for the future. When a company is not doing well, a company would think twice, thrice. The promoter would think, if I do some transactions which are not acceptable, then it might get reversed. So that deterrent has to be built in. So now, how to go about doing this? And then the first initial analysis will also help us to file an avoidance application before adjudicating authority, which is the responsibility of the RP. Now, RP has to, basically it is the responsibility of the RP who has to do this. Now, in the CAIRP, there are always timelines for different things. And then there are timelines for PUFE transactions also, which we are familiar with. Regulation 35A of the CAIIB regulations. It says that RP has to form an opinion on the preferential and other transactions. Form an opinion is something very important. That has to be done within 75 days of the commencement of the CAIIB. And then after that, within the next 30 days or 40 days, he has to make a determination, that is what exactly is wrong, and then how, and quantify the loss, and then file an application before adjudicating authority for relief. So these are the timelines which are to be kept in view. The timelines are important because only RP can file the avoidance application. So there was a case of Ambit Finvest Private Limited and Rakesh Niranjan Ranjan, where NCLT Mumbai, in this case, what had happened, the application under Section 66 is filed by one of the financial creditors. The financial creditor filed and he said, we want to claw back or we want to reverse the transaction and all that. But the bench held that only RP can file the avoidance application and not any creditor or anybody. But of course, there's an exception for undervalued transactions. We'll come to that a bit later. Now, when the law says that only RP can do it, any inaction of the IP frustrates the court and CAIIB regulations, highlighting the role of IP in PUFE transactions. So when he is the only person who can do it, so he has to do it. If he doesn't do it, then the entire opportunity is gone. So that is the importance of RP's role in this process. It is the end of the matter if IP is satisfied and there was no reason. Suppose IP says that, okay, I have verified and I'm satisfied that there is no reason to file an avoidance application. Then there is no question of appeal or somebody questioning that. That is the end of the matter. So the basic point we are trying to highlight is that RP cannot escape liability in this regard, as law assigns statutory responsibility to the IP in recognition of his ability, and thus cannot be outsourced. It cannot be delegated, it cannot be given to somebody else, and we cannot ask the COC go and file a avoidance application. Unless you are convinced, you cannot do it. So this is the broad background on which we are going to discuss today. So now I will move on to the different types of PUFE transactions. We know that there are 4 types of transactions, and they are preferential transactions, undervalued transactions, extortionate transactions, and fraudulent transactions. So before I go forward, anybody wants to make any comment or any observation, maybe you can make. Otherwise, I'll proceed with this, the concepts. So now, first major thing is this preferential transactions. They are covered by Section 43 and 44 of IBC. Then you have undervalued transactions. Third category is extortionate transactions, and fourth is fraudulent transactions. So now let us start with preferential transactions. So basically what I've done here is that I've tried to break down the definition given in the code into different parameters so that we understand the importance of each parameter. So now what is a preferential transaction? A transaction is treated as preferential transaction when the liquidator or the RP is of the opinion that the corporate debtor. So here the first thing is liquidator or RP is of the opinion. So the opinion of RP is what matters. The section clearly says that he has to form an opinion. It is, as I said earlier, it is not that security, SCOC or somebody else can do it. So the liquidator or RP is of the opinion that the corporate debtor at the relevant time meaning depending on the transaction, whether it is a related party transaction or a related party non-related party transaction, whether it is 2 years or 1 year. So whichever relevant time, we'll discuss more of this time. So at the relevant time, has transferred a property or transferred an interest in the property. So there has to be a property and property which is already available to the which is owned by the corporate debtor, and the corporate debtor has transferred this property. And this property, and when this transfer has taken place, it must be for the benefit of a creditor, surety, or guarantor, and for an antecedent financial debt. So debt has to already be there, existing debt for the if you benefit a creditor who has already given a debt, either a financial debt or a operational debt, which has the effect of putting the creditor in a beneficial position. So one thing is that corporate debtor has to do it. He has to transfer a property, and that should be the benefit of a creditor, and that for a already existing loan, and then that the result being that the creditor is put in a beneficial position in the event of a distribution. These are all the different parameters which are going to be very important in deciding whether a preferential transaction has occurred or not. The second part of the section, if you go, it says that what is not a preferential transaction. So a transaction is not treated as a preferential transaction when the transfer is made in the ordinary course of business or financial affairs of the corporate or the transferee. When a security interest secures a new value after signing of a security agreement and after registering with information utility. So basically, if the corporate debtor is doing something in the ordinary course of business, that cannot be treated as a preferential transaction. So there could be a lot of analysis and debate whether something has happened in the ordinary course of business or not. That is a matter of detail, which we need to see. But if it is happening in the ordinary course of business, the transaction cannot be treated as a preferential transaction. And second aspect is that when, suppose the corporate debtor is giving a security interest, and suppose an additional security has come in, and that security is having an agreement, security agreement, and then all the processes are followed, in that case, then it is not a preferential transaction. And but one more which is highlighted in the explanation is that if a court is directing a transfer of property, you cannot say that, okay, since court has directed, I have done it, it is not a preferential transaction. You cannot say that. There could be a transaction which can be categorized as a preferential transaction in spite of the fact that a court has directed it. So now these are the basic items. Now there are so many items which are here. So what I thought was we can look at some examples to see, to have a better understanding of the definition. Now I'm going to give you some examples. A COC member contends that the promoter of the CD has paid off a loan of rupees 5 crores given by his brother from CD's funds just before commencement of the CAIIB. This member files an application before AA for treating this transaction as a preferential transaction and prays for reversal of the same. So this we discussed briefly now, because as CD is, there is a preferential transaction very clearly, and then but the question is, who has to say that this is a preferential transaction? If CD or one of the COC members say, is it agreeable? Screen. Sorry, just a second, please. Now. Okay, so now anybody wants to react whether this is a preferential transaction, whether we can proceed for avoidance? So the answer is This is a preferential transaction worthy of avoidance. However, the important aspect is as to what is the opinion of the RP. Only he can file the application for avoidance. But what CVC member can do, he can give all the details to the RP and help him informing that opinion. That he can do. So next example. The director of the corporate debtor transfers or registers a security interest in a property in his name to a bank for an antecedent loan given to the CD. Now, a director, his own property, he is giving to a bank as an additional security, and the loan is taken not by the director but by the corporate debtor. Whether this would constitute a preferential transaction?
I think no, sir.
Yeah, corporate debtors' assets are not involved. So, hence, this is not a preferential transaction. You see, initially when we definition, we said RP has to form an opinion and the transaction has to be done by corporate debtor. In this case, corporate debtor is not involved. Hence, this is not a preferential transaction. Now, let's move on to the next example. The CD sold a property of the company about 2 years and 3 months before the start of the CAIRP to one of the directors. So the CD is sold to one of the directors. There was no specific charge on any creditor on that property. The proceeds of the deal were deposited in the CC account of the company with one of the banks. So what has happened? CD has sold the property. That is a thing. And then money has come and the money has been deposited with one of the banks. So what happens is, suppose some 5 crores property is there and then this 5 crores has gone to one of the bankers. That banker will be put in a beneficial position. So this is a transaction, preferential transaction or not?
I believe it is not, sir.
Okay. Can you explain, sir?
No, because the period is more than 2 months, 2 years.
Exactly. Correct, sir. So the transaction per se is a preferential transaction, as the bank in which the proceeds were deposited will be put in a better position compared to other creditors. However, the transaction relates to the period prior to the prescribed look-back period. So this will not be, so even it is a preferential transaction, but since it is beyond the look-back period, the court will not accept this. So, but one thing we need to see is whether it is an undervalued transaction, because I did not give what is the value. If it is an undervalued transaction, there could be that, these two, depending on whether it is a fraudulent or something like that, then this 2-year look back period may not apply. But we'll come to that when we see the undervalued transactions. So now let us go to the next example. An application for admission of CIRP of Agile Real Estate Developers filed by Home Buyers Association is pending. So home buyers have formed an association, they've gone against the real estate developer. But before disposal of the same, the CD hands over possession of 5 completed apartments to the respective home buyers who had booked the apartments. So some 5 which are ready, that was transferred. Within the home buyers, some people are getting a benefit. So CIRP was admitted 3 months later. So clearly some home buyers are getting benefited, though all the home buyers have gone to the court. So whether this is a preferential transaction?
Very difficult to say, sir. Very difficult to say. In that case, there may be claims of the home buyers who have lost the IBC application and they are getting allotted they may not be, the threshold may go down. Maybe
Yeah. No, threshold is another matter. Let us assume that threshold is not going down. That 10% and all, that threshold is not going down. That
preferential transaction may not be there exactly because there must have been some allotment process. They must have booked some specific flats and they are ready and they are being given. How it is preferential?
okay.
Sir, if it's in the normal course of business, I think it's not a preferential transaction.
Exactly, sir. This is a normal course of business because real estate developer is doing the transfer in his normal course of business. So, so the second part of the definition, if we had seen, what is not a preferential transaction was given. If it is happening in the normal course of business, this is not going to be a preferential transaction. So, so each item I have tried to give an example and try to clarify. Okay, now there is one more example I'm giving. BCD Limited had borrowed from a consortium of banks on the strength of corporate guarantee given by his holding company ABC Limited. BCD Limited buys an industrial land using internal cash flows, but the property is registered in the name of ABC Limited. So this subsidiary is buying the property, but the registration happens in the name of the holding company. But the money, of course, is used, the creditors' money, the subsidiary has used the facilities given by the consortium of banks to the subsidiary. So now the BCD becomes insolvent and the CAIIB commences 15 months later. So now, what is the position? Whether this is a preferential transaction?
Seems to be a preferential transaction.
Because BCD has transferred to somebody who is not a financial creditor. What we thought was, if it is happening between creditors and the creditors is put in a what you call advantageous position compared to other creditors, then this becomes a preferential transaction. In this case, ABC is not a financial creditor. Any thoughts? Well, this is going to be a preferential transaction benefiting the guarantor of the CD. So when you see the original definition, it could be a creditor, surety, or guarantor. So though creditor is not involved here, this is a preferential transaction benefiting the guarantor of the CD. Hence, avoidance application has to be filed. So that is the opinion, my opinion. So now, one more example. Indian software company enjoys credit limits of 175 crores from the consortium of 3 banks. The company takes an additional loan of 25 crores from the Great Bank, the leader of the consortium, for purchase of a new software from a US company worth rupees 40 crores. So the loan is 25 crores. Property is 40 crores. Security interest in this property is exclusively charged to the Great Bank, and the same is registered with IU as well as SI within 30 days. So the requirements are complied with. 6 months later, CIRP of this company is admitted based on the application filed by an operational creditor. COC asks RP to file an application for avoiding this transaction as it is a preferential transaction. So now it is a new loan given and a new security which is coming to the pool of this. But only thing is it is charged to one bank. So now the one bank which has given the loan is getting benefited by maybe 15 crores because they have an additional security under. So now the question is whether this is a preference. COC, other members of the COC say, no, you have to file an application. Now, as an RP, what is your opinion?
We have to look into consortium agreements, because this limit has been announced.
Okay.
And then new property has been bought.
Correct.
So there may be some conditions in the loan agreement. And based on that, we have to take a decision.
But consortium agreement, what does it say? Consortium
It may say
agreement.
that any additional property brought should be charged to all the lenders. Maybe.
No, generally consortium cannot have such an agreement that if whoever is giving loan and exclusive charge is generally it is permitted within consortium. Exclusive charges is permitted. Or what they say is that you have a first charge. The lending bank will have a first charge and others will have a second charge. But it cannot be said that no bank, see, within the consortium, suppose other people are not ready when one bank wants to give a loan, it is not that you cannot give a loan. You can give.
Yes.
Maybe sometimes banks do out of the consortium also. The specific loan they give and they say this is not part of the consortium.
No, but if it is a agreement other than the consortium agreement, other facility than the consortium, then certainly I don't think that falls into preferential transaction.
Okay. So basically what my feeling is that since I going by the definition, I'm not going to the consortium agreement and other agreements or understandings. Going by the definition here of the preferential transaction, since the new asset is created and security interest on the same is created in favor of the creditor. See, the second part of the definition, what we discussed, what is not a preferential transaction, I showed. If you want, I can show it again. So since the second part, I'll just go to that and show it to you.
Antecedent.
Yeah. The second part.
Antecedent.
A transaction is not treated as a preferential transaction. The second part, if you see, when the security interest secures a new value after signing of a security agreement and after registering it with an information utility. So this is not a preferential transaction. So going by the definition, because an additional security is created and proper agreement is there, it is not that something underhand has happened and everything is properly done and a creditor is involved and who is providing a financial service. So all these things are there. So because of this, my understanding is that this is not a preferential transaction. Okay, one more example I can show you. The accounts of RRR Private Limited were frozen by their bank in response to a notice by the GST department, which made a claim of 3.5 crores on the company. In order to ensure continuation of the business, the company deposits this amount with the GST department. CIRP is admitted 6 months later. COC asked the RP to examine if this payment could be treated as a preferential transaction. Because COC members feel that 3.5 crores has gone to GST department, which should have legitimately been with the secured creditors. So whether this is a preferential transaction. Any opinions?
No, I don't think.
Yeah, because payment of taxes to government dues are not treated as preferential transactions. Because it is a what you call responsibility, you have to pay. So it is not that somebody is benefited out of this by the it is not that this creditor, the corporate debtor is benefiting somebody because he has to pay the taxes for the business which he has done. He has to pay it. So it cannot be treated as a preferential transaction. Now let's see another example. Messrs. KK Enterprises has been having financial stress for the last 6 months. Salary dues of the creditors and employees to the extent of 2 crores had piled up. The management makes a payment of the overdues after recovery of dues from some sundry creditors. In the next 3 months, CIRP is admitted. So now whatever pending salaries were there, they have paid. They got some money and they have paid. But the stress continued and then ultimately it became insolvent company. Now payment of salaries of 2 crores to these workers and employees, can this be treated as a preferential transaction? Suppose the COC member says, no, it has just happened 6 months before, so that money has to come back. So what is your understanding?
Not sure, sir. But should we know?
Payment of salaries to workers and employees is not treated as a preferential transaction. Though strictly it is not mentioned in the definition, but this is the interpretation of IBBA and all that, when it is similar to tax payment and salaries have to be paid to the workers and employees. And they also have a kind of same level in the waterfall mechanism as secured creditors. So we cannot
And
say
sir,
that.
if it is made to only to select employees, in that case,
maybe that can be treated as a preferential transaction. If because see, what is happening is basically we are some overdues are there to the people, and then some overdues are cleared and some overdues are not cleared. Well, it
so
is possible.
there may be some situations. Say the outstanding is 2 crores, the company gets say 1.5 crores, that
Yeah,
distributes pro rata.
yeah.
That's perfectly fine. But if some of the employees are left out with nil payments,
No,
in
if
that
some of the due left out, I mean, only thing these some of the left out employees can claim is that you bring that money and distribute it equally or proportionately. That is what they can claim.
yes,
Probably, yes, your argument, I would go with that. But generally, payment of salaries is not considered a preferential transaction. But there is some preference inter se within the employees. Maybe there is a case could be built up.
yes, yes.
But it is not going to benefit financial creditors.
Mm.
So another example I have. Mr. SD Limited had taken a short-term loan from Bengal Bank against mortgage of a property of the director for peak season sales payable after 12 months. So basically, he has taken a what you call a temporary overdraft (TOD). So they have taken and then a short-term loan, and then the loan was paid off by the company after 6 months. Okay, and the property was got released. So director had given a property, and then loan was taken and it was closed. 3 months later, CAIIB commences. Can we file an application for getting this property charged to the creditors?
No, sir. It's not a preferential transaction.
I think it is.
The loan was taken and the loan was repaid.
Sir, I think it is. It was to be paid in 12 months. It has been paid before, much before that.
Yeah, exactly. And the clue is that 3 months later, CAIIB has commenced.
Yes.
So, which means that he should have paid after 12 months. It becomes due, but he has paid in advance. So, which means that he is trying to see that the director is not affected because of the financial stress. So, this may be treated as a may be treated as a preferential transaction. And then RP has to initiate for avoidance. So let us move on to one more example. You read it, I'll just back in a minute. Okay, sir. Sorry for that interruption. So now SD Limited has taken a short-term loan from this. We have said, and we said this has to be a. So this is another example. Is AA Pharma. AA Pharma Limited gives an advance of ₹5 crores to API Limited, a critical raw material supplier, using their working capital limit to ensure uninterrupted supply of raw material. Okay. So before supplies could be made, CIRP of AA Pharma is initiated on 1/4/23. API appropriates 2.7 crores in May 2023 towards its running dues, and then supplies raw material of 2.3 crores to a sister concern of AA Pharma. Probably the director said, okay, now this has become insolvent, don't give the material to them, give me to this another company. Now, how this transaction is to be viewed under Section 43? So the raw material supplier can be given an advance payment because that is part of the business. So now how he has to do it? So answer is that API for 2.7 crores they have appropriated for their earlier dues. But whether that is in May 2023, I said. Then the CAIIB started on 1/4. So we need to see what was the dues on the commencement of date, commencement of insolvency. That is, suppose it is only 2 crores. 2 crores he can appropriate because it is before the commencement. And then for the remaining amount, he has to make a claim. So 2.3 crores, which he has submitted to sister concern, that will be a preferential transaction which has to be avoided. Any opinions on this? Okay. So now, so we have discussed several scenarios and then where professional transaction. So now we basically have an idea like how to go about this. Then I'll move on to the next category of PUFE, that is undervalued transactions. Undervalued transactions are basically very simple to understand, that somebody is selling a property for less than the value. So this for undervalued transactions also there is a look back period of 2 years in respect of a related party and 1 year in respect of a party other than the related party. And this is under section 46. Okay. And there is also another clause which says that somebody buys a property, a third person which buys a property in good faith and for value and without any notice of the relevant circumstances. In that case, you cannot go for a clawback against this person. Suppose he has purchased in good faith and he has given the value, whatever value which was demanded, and then he doesn't know that CIR. But one thing generally the interpretation is that if a public announcement is made about starting of the CAIRP, then it is considered that people know that there is a CAIRP or there is something. So after that, some property is purchased or anything like that, then we can say that he has not purchased in good faith. So basically, and now let us see what exactly the section 45 is saying. A transaction shall be considered undervalued if the corporate debtor makes a gift to a person. Corporate debtor, the property, he has a property. Property could be not only this immovable property, it could be some other things also, some goods, some. There's a definition of a property in section 3. So if those things, anything which is given as a gift, and if suppose if the value is there, then we have to see whether that can be treated as undervalue. And the second aspect is that the corporate debtor enters into a transaction with a person which involves the transfer of one or more assets by the corporate debtor, okay, for a consideration, the value of which is significantly less than the value of consideration provided by the CD. So CD has purchased for say 1 crore and is selling for 50 lakhs, then definitely there is some something irregular, and then RP has to see. He has to go further into the why this has happened and whether it is undervalued. That examination has to take place. And then again, this ordinary course of business is coming into place. Suppose this apparently this is undervalued, but it has happened in the ordinary course of business. But I mean, we can understand how any property can be sold for a lesser value, even if it is ordinary course. There cannot be such an ordinary course of business where this is done. But some provision is made, maybe to cover some unusual situations. Maybe some COVID is there and people are selling for less, and probably the company has done this. So that is the way. So basically, if a gift is given and then if the value for which it is transferred is less than the value which has been acquired, then it is an undervalued. And this is basically, I think, what we can commonly understand. There are undervalued transactions which are covering under section 49 also, apart from section 45. See, now the transactions as defined under section 45(2), that is undervalued transactions, if deliberately entered by the corporate debtor. So here the question is, the intent comes in, whether it is some normal transaction has happened undervalued and they have lost money, that is one thing. But if it is deliberately done by the corporate debtor, for what purpose they do deliberately? For keeping the assets of the corporate debtor beyond the reach of the creditors. So some value property is there, and then that CAIRP is coming. Then just before CAIRP, you transfer the property to maybe some related party. So some maybe 10 crore property, they want to see that it doesn't go into the hands of the debtors, creditors, and then you transfer it. If this happens, to deliberately to keep the assets of the corporate debtor beyond the reach. And second aspect is, in order to adversely affect the interests of the such creditors, okay, then in that case, adjudicating authority shall make an order restoring the position. But again, here also the good faith aspect comes in. If a person is entering into a transaction in good faith for value and without notice of relevant circumstances, then it doesn't become an undervalued transaction. So it's a matter of when you file an application, you have to convince the bench that this is not in the normal circumstances, or the purchaser does not know, that we have to convince. I mean, he knows, basically we have to convince, so that the clawback happens. So now we discussed undervalued transaction under two sections. One is 45 and 149. The original one said. So now let us examine a few points, what exactly is the difference. So under section 45, all undervalued transactions are covered under this section, all in the section 45. And then intention is not considered under section 45. And then look back period is applicable. When you move to section 49, well, suppose you try to build up a case saying that a particular undervalued transaction has happened with the idea that the creditors should be misled, or they should be left, they should get a loss or something like that. So section 49 comes to the picture. So section 49 deals with transactions undertaken with malafide or wrongful intent. So again, this is similar to a fraudulent transaction, but where valuation is there, it is coming under section 49. And then fraudulent transactions under section 49 and section 66 do not have any look back restriction. So this is an important difference between section 45 and 49. If it is an undervalued transaction, you try to build up a case saying that this is wantonly done, this intention is bad, then the look back period does not apply. Because if it is a fraud, then it is always a fraud. So you cannot say that 2 years have passed and fraud becomes a normal transaction. It doesn't happen then. So now there are some examples of undervalued transaction, because mostly we can understand. But when you are trying to understand the takeover charge of a corporate debtor and how it is going, in that case, what are the different things which we have to look at? See, some examples of undervalued transactions is suppose you notice that there is a sale of office space. Office space is given to suppose an allied concern or some associate company moves into the office, and these people close the office and they move or the cars are there. So a lot of all senior officials might be having cars. The cars are sold either to the senior officials themselves or to directors or some related party. Then you have to look at the value. Whether, of course, some depreciation will be there, but then we have to see whether then there is serious undervaluation. The shares of the subsidiary company, you need to see whether any subsidiaries are there and whether any transactions are taken place. The subsidiaries, the value, the shareholding has moved to some other person. In that case, it will be an undervalued transaction. Not just the physical assets, shares And then a business franchise. Suppose a particular section of the business is sold off to somebody, and we have to check whether any undervaluation is there. And then sale of a brand, a trademark, copyright. All these things also to be need to be looked into. If any such thing happens, whether we need to see any scope for treating this as an undervalued transaction, we need to see. So brand, trademark, copyright, intellectual property, whether that is to be seen. And then another aspect, which is write-off of sundry debtors, advances, without valid reasons and without effort for recovery. So this is a very common thing. We will see that after the business starts going down, you are not able to recover the sundry creditors. And what efforts have been taken by the corporate debtor just before the CAIIB commencement, whether they have done something, whether some notices are there, whether some efforts are there. And without any effort, because this happens because sundry debtors could be related parties. In that case, they get a benefit. So that should be treated as an undervalued transaction. And especially if you see some hanky-panky, then it is under Section 49. So this is basically about undervalued transactions. And then we'll move to the third category, extortionate transactions under IBC. Before I go to this third category, any observations, questions, or anything like that, we can just look at that. Okay. Now, third category is extortionate transactions under IBC. What are extortionate transactions? Because if the corporate debtor is taking a loan at a very high rate, that will be extortionate, because extortionate credit transaction is a transaction. It is not just extortionate, it is extortionate credit transaction. Extortionate could be anything. It's a criminal offense, extortion. It could be anything. It could be kidnapping or anything like that. But in our context, it is extortionate credit transaction. An extortionate credit transaction is a transaction for involving the provision of credit to the corporate debtor by any person on terms requiring the bankrupt to make exorbitant payments in respect of the credit provided. So, if somebody is, if you're taking a loan from a related party or some associate or something and saying that, okay, I'll pay 36%, and you actually pay it also. Then what is happening is that the net worth or the assets of the corporate debtor are getting depleted, because you are moving away the money to another person, giving a reason that okay, I borrowed at high rate, that is a market is tough, I'm not getting a loan, so I've gone to this person, he is ready to give a loan at maybe 5 rupees per month or something like that, then we have taken this. Then it is a high probability of an extortionate transaction, and then we have to see this. Basically, there is some explanation also given. One is that exorbitant rate is there, and second thing is that unconsignable under the principles of law relating to contracts. This is the explanation given in the regulations. So, I mean, basically you find that, no, somebody is buying, the market is going at 9%, 10%, you borrow at 36%. Then how it is possible? But one question that comes up is, now most of the people, there is a corporate credit cards are there, and some corporate has taken a loan under credit card. Okay. Credit card normally charges 36%. Whether that will be an extortionate transaction? Morally, maybe yes. But then as per definition, debt extended by a financial service provider in compliance with any law shall in no event be considered as an extortionate credit transaction. So now what happens is that if a registered NBFC or bank is giving high loans, and that is part of the, it is a regulated entity, then it is acceptable. Even microfinance could be sometimes very costly. But those things are not treated as extortionate credit transactions. But only if the agency is other than that, it is treated. Now, let us see some examples, which we, of course, we have discussed also. Unsecured loans at an exorbitant interest rate and difficult terms, borrowings from directors, related parties, associate concerns at high rates. These are some of the things. Obviously, you have to see whether there is something wrong. Some extortionate credit transactions happen. So if he notices that, then our liquidator can apply for restoring prior position, setting aside the debt. So you can ask for modification of the terms. So instead of 36%, you will say, okay, I will pay only 12%. Or you say that instead of 12 months, I will pay in 36 months. So these kind of prayers can be made to the NCLT. So this is how the extortionate credit transactions are to be dealt with. Okay. Now, next category, the fourth category is fraudulent trading or wrongful trading under IBC. So now, any business of the corporate debtor that has been carried on with the intent to defraud creditors, and the business is carried on for any fraudulent purpose, then it is called a fraudulent or wrongful trading. So basically, the idea here is that if the idea is to cheat the corporate, cheat the creditors, financial creditors, or any kind of creditors for that matter, then that you can identify that transaction and say that this is a fraudulent transaction and which needs to be reversed. A director of the corporate debtor knew or ought to have known that there was no reasonable prospect of avoiding the commencement of CAIIB. Now, this is basically with the reference to wrongful trading. So wrongful trading is most of the times the business is not profitable. We know that it is not work. Just because there is a credit limit going on, you continue the business even if it is loss making. Then, because if the director knows that there is no reasonable prospect of avoiding the commencement of CAIIB, if that situation is clear, and then you continue to do the business, then it can be treated as a wrongful trading. Such director or partner did not exercise due diligence in minimizing the potential loss to the creditors of the corporate debtor. So what is the question of minimizing the potential loss? So I was referring to this twilight period when the directors, the promoters know that this business is not going to survive. It is going to fail. Maybe most of the people will know within 1 year or prior 1 year, 2 years before. But at that point of time, then suppose the director takes, he transfers the properties, then he sells off some things to sundry creditors, he adjusts, and some manipulation takes place so that, he's trying to protect his interest vis-a-vis the interest of the corporate debtor. If that happens, then it is clearly a wrongful trading. Then the section 66 gets covered. But see, there are so many examples like how this wrongful trading or fraudulent trading happens. Most of the most of the chartered accountants, advocates, and all that who are IPs, they know what are the different types of frauds. It is like, once you see the company, you discuss maybe for a day or two, then you will understand that these are some transactions happened, which is a fraud. Now, some examples we are giving. Any transaction with the objective of keeping the asset or property of the corporate debtor away from the creditors. It's a general observation saying that, as I said, the director can transfer the property to somebody, his relatives or something. Then, even if it is his own property, which is mortgaged, then it can be treated as a fraudulent transaction. Then, regular thing, what happens, manipulation of books happens. What happens is you give false statements, stock statements. Forged documents or bills of exchange are given. Sale bills for discounting are given. Export and import bills, which without any export, they are given. Without any actual import, you try to say that you have imported something. Then falsification of books. These are all very familiar things. Recording fake transaction of sale and purchase for obtaining increased credit limits. Making entries of bogus expenditure for diversion of funds for personal gains. So you make an entry and then personally you take out the money with the objective of increase in assets of the corporate debtor in the books of account to present a rosy picture. So these are some of the things what we generally call as falsification of books. So this is something which becomes fraudulent. So coming back to our original picture, when the IRP within the 30 days, he takes charge of the things and he tries to understand what the company is and how it has become insolvent and all these things. See, he has to notice all these fraudulent transactions. They make a list and then try to quantify what could be the amount of loss we have to see, and then understand then how to really fix the errant promoters, how to really find out. So one thing is, you know that something is bad, something is dal mein kuch kala hai, that much you could understand, but then that doesn't stop there. So initial process is this, and you need to, suppose you see an entry which is could be suspicious, then you have to get all related books, verification. So how this analysis happens, that we'll go and we'll see in the going forward, that we'll be discussing. But the basic idea is that apart from your CAIIB efforts, that is, you're trying to find a resolution applicant, you're trying to find a plan, and you're trying to talk whether OTS is possible, you're trying to see whether 12A settlement is possible. All these things parallel will go on, but at the same time, you should be acting as a Sherlock Holmes and trying to find out what is whether this fellow is a genuine fellow, and whether the business has gone into loss for a genuine reason, for a what you call business loss, ordinary course of business, or some fraud has happened. That we need to look very carefully. Then only the CAIIB as a whole will be successful. And some more examples of fraudulent transactions are in this slide. A siphoning of inventory stock of the corporator by showing increased consumption. And then submission of fake financial statements to banks. That is what you call, you give one statement to banks, one statement to income tax. It has happened nowadays. Of course, a lot of steps have come in where because banks also nowadays, they go and verify the income tax site and check whether the same balance sheet has come. So this has happened earlier so many times that you give something, a rosy picture to the bank, and then very gloomy picture to the income tax department. And then fraudulent removal of property of the corporate debtor that we just mentioned. Undervalue transaction with fraudulent intent. This is section 49, which we just discussed, with intent to cause loss to the security interest. And then lack of diligence while doing business during twilight zone, causing loss to the corporate debtor and thereby to the creditors. So whatever some actions taken by the promoter during the twilight, when just before the CAIIB starts, then we need to see whether he is trying to protect his interest, or is he trying to protect the interest of the corporate debtor, all this other stakeholders he is trying to protect. So basically we have discussed the 4 categories, and then just finally, before we move on to other things, I just wanted to tell you, we have I summarized what exactly. So whether the transfer of property happened for the benefit of the creditor, surety, or guarantor, and whether such transfers have put him in a beneficial position than what he would have received in the event of distribution of assets. This is the basic crux of the matter as far as preferential transactions are concerned. Secondly, whether a transaction transfer is made in the ordinary course of business to the corporate data. If it is in the ordinary course, then it is not a preferential transaction. Third aspect, which briefly is that whether the transfer is made for the consideration which is significantly lower than the consideration of the for which CD has purchased. So the first two cover the preferential, third one is undervalued, and fourth one is whether the transaction require corporate debtor to make exorbitant payment in respect of credit provided, and whether the transactions are unconsignable under the prevailing circumstances. This relates to extortionate credit transactions. And the fifth one is whether the transfer of property affects the interest of the creditors and affects the resolution process in terms of value. And this is wrongful trading, and whether funds have been raised to remit elsewhere without any deployment towards the core business of the company. So these are some of the things covering, these are the core questions which have to be kept in mind when you start the CAIIB process. And within the first 1 or 2 months, we have to come to a conclusion. That is the question of forming of the opinion, because RP has to form an opinion and then we need to see. So now let us discuss a bit detail in what is this forming of opinion on preferential transactions, because a lot of importance is given, because in the initial stages, RP or IRP or RP he has to form an opinion. Why this is important? Because if you see the roles and responsibilities of the RP, this is an important action point which he has to comply. Section 25(2)(j) stipulates that it is the duty of the resolution professional to file for avoidance transactions, if any. So since only RP or liquidator can file for an avoidance application, not doing so deprive the opportunity in maximization of value of the assets under insolvency resolution. So this is a very important duty. So that for that purpose, we need to do this. And second thing is, RP has to confirm in Form H. Form H is when you submit this resolution plan, you give a compliances, all the compliances which you have ensured, that has to be given in Form H. So one of the aspects of Form H is that whether the RP has made a determination if the CD has been subjected to any transaction of the nature covered under Section 43, 45, 50. So even if you are focusing on resolution plan, at the time of submission of the resolution plan to the adjudicating authority, you need to give a confirmation that, okay, I have taken, and if you are giving a false confirmation, then action can be taken. And there's one more section which, this is as far as liquidation is concerned, which says that Section 35, which enjoins upon the liquidator to investigate the financial affairs of the corporate debtor to determine the avoidable transactions. So these are all the provisions within the IBC and regulations which make it compulsory, which is mandatory for the RP to look into these things. So it is not that we'll see if something is possible, not as a side track. You have to do it. That is your responsibility. Then there's one more section, Section 47(2). That is what undervalued. If the RP or liquidator does not report undervalued transactions to adjudicating authority, then what happens? Even after having sufficient information of such transactions, then the disciplinary action can be initiated against such RP liquidator. This is provided in Section 47. Especially this is with reference to undervalued transaction. You see an undervalued transaction, but you just ignore it. Then it is the other people can file it. The creditor can file, and any other shareholder can file and saying that some undervalued transaction has taken place, but RP has ignored it. Then in that case, adjudicating authority will ask IBPA to initiate disciplinary action. Then the primary responsibility in relation to action on PUFE transactions would lie with the RP liquidator, which I have emphasized so many times. There could be a professional. You can appoint a professional to find out whether any avoidance is possible or any forensic audit is required to be done. But then it is only a facilitation to the RP. You cannot say that forensic auditor did not tell anything, so I did not file. You cannot, because the responsibility lies with you, and it's only whatever the other people do, other professionals do, it is only a facilitation to the function of the RP. One more thing which we need to see is, you cannot say that, okay, COC is not interested, so I did not file. No, that is not possible, because there is no requirement of taking approval from COC for filing the application determining the avoidable transaction. In fact, COC has no role here. The RP is required to take approval of the payment of fee to the auditor, and other professionals only thereafter inform the COC about filing such transactions. Filing he has to do, but he has to take approval from COC for the fees. So at the time of asking for approval for the fees, COC may say, no, it is not required. Now, in that case, you have formed an opinion on certain facts. You have observed certain things that you need to explain to COC and say that, see, I see so many things which has happened in this company. So it is better that we look into this and go deep into this. Otherwise, what happens is that you will not be in a position to comply with your responsibility. So where COC is not cooperative and does not ratify the fee of the auditors and legal counsels, so what do? You cannot simply say that COC did not agree and then we do it. Then what? The RP shall record all the deliberations in the COC minutes, then file an application seeking appropriate directions from the AA. So what you have to tell the adjudicating authority, sir, this is my responsibility, but I am not getting COC's approval for payment of fees. So now what do you want me to do? So then maybe you will explain to the adjudicating authority also on what basis you think filing a avoidance application is very important. So that would help. So these are some of the things RP is required to do. And there are some more things. Let me see. As far as now, we are saying that, oh, no, your responsibility and all that. How now? I'm trying to understand what are the assets, what are the sources available to IRP or RP, where it is. So you have with you admitted claims. So by 30th day or something like that, in fact, by the time you constitute the COC, you have more or less all the admitted claims. And then once you see the claim, you know what is the basis, whether mortgage is there and what property is there, and you get a list of all the things, what has happened, which lender has given what loan, for what purpose, what are the terms, all these things you come to know. So you have admitted claims, you have assets mortgaged to banks and other lenders, because they're all given in the claims. Then you have bank statements, bank account statements as part of claims, especially for the twilight period. So you need not take 15 years statement, but at least immediately 2-3 years statements will definitely come to you, because by the time NPA has come and then before NPA, all these details will come. So then you have broad details of the fixed asset. We should ask for the fixed asset register. That is a very important register, which as a CARP which is required, and RP has to have it. And then if that register is available, and then you have the information, you visit the plant, you visit the factory if it is there, and information from plant, office visits, and physical verification while taking charge of the CD. All these things, if you are done, you get some basic idea what are the fixed assets with the corporate data. Then you also discuss with promoters, suspended directors, and other staff members. You discuss with auditors. This is a very important thing. You discuss with the statutory auditors how exactly the company has been run over the period, and what are the things which went wrong, all these things. And data downloaded from MCA, ROC sites, such balance sheets and such reports. Then even if the company is not giving you the balance sheets, you have to go to a MCA site and download the balance sheets. At least last 1 or 2 balance sheets you'll be available, and then you try to maybe in the last year, or this is suppose 2023 may not be there, at least there'll be 2020 or 2019. So whatever is available, you try to download, and then you discuss with employees, workers, what happened, and then you discuss with financial creditors, COC members. So all these things you can do to collect information as to what went wrong. Depending on that, you will know whether it is a straightforward business loss or it is straightforward fraudulent transactions have happened. Then generally, how this is a general thing, like, how it is to be done. We need to collect all information, try to find out which is the main thing, whether any related party is involved, what exactly has happened, when a sale has happened, property has sold, how things are. And then you need to find out vulnerable transactions. And then the classification of transactions needs to be done. Related party, non-related party, and then within the look back period, outside the look back period, all these things we need to see. And then at that point of time, we will come to a conclusion whether more details can be unearthed from the transaction audit. So now this is the process, which is a general thing, which we need to do, and then we need to come to a conclusion. So second thing is, then you discuss with the COC. Then what discussion with the COC is required? You need to give the facts to the COC, and you say that a transaction auditor is to be appointed. But what is emphasized is you don't have to get an approval of the COC. You tell them, you place all the facts before them, you keep them informed. Not only COC, you need to keep informed the suspended directors. You need to talk to them. Look here, this has happened, and why this has happened. You need to discuss a particular transaction, then you can check with him. So once you get all these things, then you will be in a position to file an application. This is the process which you need to go through. And that is where, when you are ready to file an application for avoiding. So now, a related topic which we wanted to discuss today, in the process of forming an opinion and then forming whether something has gone wrong to file an avoidance application, what we need to do is, there is a financial analysis we need to do. Broadly, I've been telling you on these things, but we'll go into more specifics. Identification of potential threats on PUFE transactions through financial analysis. So we'll be talking about some red flags which have been listed out by IBBI. If those red flags are there, then immediately you'll have to understand that something is wrong. So the idea is that if there are red flags, you cannot go and say to adjudicating authority, sir, my opinion is that there is nothing wrong. And you cannot say that there is no PUFE transactions, because there are so many red flags you could find. So what are these red flags, and what are these items which you need to see from the financial analysis? So we can discuss that further. Any observation before we go to the next topic? Okay, now.
Yes, sir. I have one query, sir.
Yes, sir.
Yeah, it's regarding, sir, suppose we have appointed the forensic auditor, but he has not found any few transaction.
Okay.
So, but in thereafter some, it's means there are some frauds are there, but it's not come to in the report. So
yeah,
it's a liability of the RP or IRP, sir. Means my question is that once we appoint the forensic auditors, RP's liability is even there, no?
No, see, the liability of what we discussed was that it is the responsibility of the resolution professional. RP has to form. So the other person, other professional is only assisting or is helping, facilitating. So to that extent, his liability would be there, we can say that, but not directly, in the sense that you cannot say that he could not find any preferential transaction. So that is something wrong. That we cannot say. You cannot file responsibility. Responsibility is yours, but your responsibility also, there is one section 223 or something like that. I'll just come to that in the course of presentation. See, the liability, if the actions of the RP, some protection is there. So you do something normal in the normal course, you take care of all precautions, and then you find after all what you call genuine efforts, you find that you are not able to find a preferential transaction or anything like that. Any PUFE is not able to find. Yes, you are in a position to explain that I have taken all the steps, but I'm not able to get anything. You should be able to explain. But I don't think any personal liability will be fixed on the RP, because all the actions taken by RP is protected if under section, that section I will come to you, section 233 or something like that. So not only in terms of PUFE transactions, in other processes also. You do something.
Yeah, I got it, sir. It's RP is not duty to just means it's a duty to find out the PUFE transaction. If no transactions are there, then if it's in the means normal course of business, then it's okay. But if some frauds are occurred, but which not in the report of the forensic auditor for which we have appointed for PUFE transaction audit. But then in this case, whether RP's liability will be there, because it's already happened. That's why I'm asking, sir.
See, the question is, there is some action of analysis of the forensic report also needs to be done. It is not that whatever he gives you take up. See,
that's I'm just.
You see, there is a scope which you are defining at the time of giving the assignment, and then you see what are the things you wanted to find, and then what are the things he has seen. And in spite of seeing all those things, he is not able to find. Then we might question, we might ask him to go further and then look more and then come up with a revised report. We can ask. Suppose you find that it is not that whatever he gives, you have to accept. That is one thing. And second thing is that, see, there could be situations where, like, you file an application also, avoidance application also, but you are not able to convince the bench.
Yes, sir, because the filing of the application is different, but to convince it's another thing, sir. Yes.
Yeah, because that is the basic problem all the RPs have been facing with regards to PUFE transactions, because you know that something is wrong, and then you are broadly able to identify, but then you are not able to convince, because there are certain doors which the promoter can escape. We'll say normal course of business, or he'll say this is done in the normal course, or this is done, no, there was some problem, I did this. So all these things, when it goes to the before bench, so they'll take a view. It is not that just because RP says it is a PUFE transaction, it becomes final. It is finally accepted only when adjudicating authority passes an order.
Yes.
So we have to make our efforts. We have to make our sincere efforts, and we have to see that all possible information is collected. In that case, we can always justify that there is no lack of effort or sincerity on the part of resolution professional. Then I think courts will definitely take that into account, and even IBBA would take that into account. So it's a matter of detail only. Whether
sir, I have a question.
Yes, sir.
Sir, I mean, just taking forward from the previous query, say if the forensic auditor is appointed and he has not flagged any items and he has given a clean report, whereas in the assessment of the RP, there are some transactions which may fall or are falling within the PUFE definition. Then whether the RP is at liberty to come out and file an application with the AA?
Yes. See, if you are very clear, see, basically your opinion is final. That's what is said. And second thing is that it is you who have to file the application. And one more thing which I'll be covering as we go forward is that it is not necessary that you have to engage a transaction auditor or a forensic auditor. It is not required. From the facts available to you, you are able to come to a conclusion that there is something malified or something fraudulent has happened. You, without
Yep.
even engaging a transaction auditor, you can file an application.
Okay,
Only
fine. Thank you so much.
Most of the RPs would, even the advocates supporting the RPs would say that, sir, why do you want to take a chance? You go for an auditor, get an audit report. And once there is very transparently, it is visible that something fraudulent has happened. No way that even the auditor who goes much detail will come out with a different conclusion.
Okay, fine. Thank you.
So now, basically, we have got a some discussion we have done about what are different PUFE transactions are there. And
Sir,
then,
if you want, we can have a short break.
yeah, sure, madam. We can have a short break before going. Maybe you suggest when we can reassemble.
Sir, as and when you require.
Maybe 10 minutes break is okay. That is okay.
Yes, sir.
Okay, ma'am. Yeah. We'll break for 10 minutes and then we'll start again. Now the time is 11 o'clock. So 11:10 we'll start again. Ma'am, I can start once we.
Sure, sir. We can start now.
Okay. Well, friends, as I was saying, we have discussed so many things about PUFE transactions, and now basically it is the RP's endeavor. Responsibility, of course, is there. But then it is the to make a comprehensive solution possible. Then we need to understand what are the things which have gone wrong, and if anything is done which is basically to affect the interests of the creditor. In that case, we need to identify such transactions and file avoidance application. And if we are able to succeed in that process, then substantial benefits will be accruing to the sundry creditors, the corporate, the financial creditors, and then maybe everybody will be benefited. And ultimately, the company will also come out of insolvency. So now I'm talking to, I'm start the process of the question is the identification of potential threats and PUFE transactions through financial analysis. So as I told you, we have so much of information there. In fact, I saw in the chat box, one question is if financial statements are not prepared at all, how to file a avoidance application. Then of course, that itself is a red flag. That financial data is not prepared is on that basis itself you can file an application. But of course, because there are so many factors, it is the responsibility of the directors of the company to file an application. And even in the Companies Act, it is prescribed that you have to file the balance sheets and all that. So that itself will form a basis for filing the application. But of course, you cannot go much deeper into the thing if you don't have the financial data. But there are other things. We will try to see whether any fixed asset which has been charged to a particular lender, it has been sold off, it is there or not there. So you can try to understand more specifically. If balance sheet is not prepared, there must be some reason which there is something which the promoter is trying to hide. So it is very difficult. I mean, we can say while discussing, but then maybe it is very difficult to put up a case which will convince the adjudicating authority. But then to file an application and see that what are the things, that is definitely possible with the other information. From the claims itself, you can collect some data. From the other information you have, otherwise talking to people. So there are various ways of collecting the information. That based on that, you try to put up a good show. Then we will see whether results come or not. Then that we need to leave it to the adjudicating authority. If authority feels that there is something more serious, then the bench might give directions to some investigating agency if the substantial amount is involved. So in that case, then more clear investigations will happen. So in this, when we try to do the financial analysis, so we have some information about the company through in the form of balance sheets and whatever is there. Then how to do the analysis is what we'll discuss now. There are red flags which I talked about, which IBBI has laid down, and then there are what are called entity level red flags, and then component level red flags. That is, there are some items which the entire picture, taking the company as a whole, you will know. And then there are certain specific things we need to see. What are the sundry creditors? What are the loans? What are the receivables? All these things separately you see and try to understand some, something irregular. So first, let us discuss about entity level red flags. So the nature of business is something which is to be seen. IP has to thoroughly understand the nature of industry in which the operation, the CD is operating, and then what are the risks involved in that. So now, so we all know, suppose it's a real estate company, there is some kind of risk, some kind of operations which take place. Suppose it is a infrastructure company, you know, something wrong goes wrong, or you find that some mining is happening. Then some other thing, major company, some production, manufacturing is happening, a product or something like that. So depending on that, there could be scope for fraudulent activity. So in fact, there are certain industries which are surprised, especially infra, especially real estate, and all these such industries. There is a high scope of PUFE transactions. That's what IBBA note says that. Okay. Certain industries are more prone to have avoidance and fraudulent transactions. Thorough scrutiny is required, whereas CD is from such industries. So nature of business itself is something which you need to consider. And then second aspect is absence of audited financial information, which I just discussed. Non-filing of audited financial statements on MCA site is a red flag. Non-preparation of financial statements and company not being subject to audit. Non-availability of audit report, such as CARO report, ICFOR, ICOFR, secretarial audit, all these. These are different types of audit reports. Depending on the size of the company, you will have all these reports. Sometimes you may not have. In that case, if you are having those reports, they'll see the observations, what is written there, what is the comment given by the auditor. All these things we need to see. And then nothing is coming. Books and records are not produced. So there are some records, but the corporate data, the promoter is not giving you. In such cases also, these are all red flags. Then based on that, you try to build up a case saying that, of course, if cooperation is not coming, we'll file an application under Section 19 for cooperation. And then we'll try to pursue that. Then we'll try to get a direction from the adjudicating authority that this should be. When suppose that direction is also not met, some people have seen they file contempt applications, and all these things are there. And I've seen a case where if the promoter is not appearing before the bench, then they'll ask for what do you call warrant also, arrest warrant. So there are different things depending on the circumstances, depending on the nature of the case, you can do that. So when the audited information is not there, then you try to see what best you can do and how to build up a case. So straight away we can build up a case saying that there is a fraud. And then of course you can get a lot of information from the bankers also, even if you are not able to get the information from the corporate data. And specifically, what kind of observations and audit reports are red flags? So there are, what happens is sometimes a qualification is given. We have not verified the stocks, or we have taken the certificate of the management. Such things are there. Suppose high value stocks are there, and then we don't know. Then we need to see why this is happening. And then there is no physical verification done. And then there is a difference between stock report given to the bank and what is available in the stock register. So if observations of the auditor are of serious nature, discuss with the statutory auditor and commence the forensic review immediately. So, you know, if auditor has already pointed out, then there is not much of exercise in forming an opinion. There is clear-cut, black and white. There is a report saying that there is something wrong, and then immediately you start transaction audit to find out what are the different lacunae. And there's one more thing also. Even if the audit report is clean without any adverse observations, then also avoidance review by the RP is required. You cannot simply conclude that just because auditor says everything is hunky-dory, we cannot leave it at that. You have to do your own exercise. Then you also have to see whether the RP to have a view on the independence exercised by the auditor in relation to the promoters of the CD. So if he is giving a clean report, whether he is biased, that is what we need to question. I'm not saying that directly it will be like that, but then there probably the company is clean. But then you have to examine this aspect. And then you also need to see whether the company is a very big company, but they have appointed a very small auditor. Small is a very relative thing. And then we have to see whether the size of the audit firm is in relation to the scale of the operations of the CD. Whether there is any discrepancy, we need to see. But depending on that, you will take a view on the audit report itself. Then suppose you observe non-compliance with accounting standards on items such as inventories, payroll costs, revenues, forex transactions, which may have resulted in excess short statements to be checked while forming an opinion. So we know all the basic accounting standards of most of the things. Suppose you say what is the valuation taken, whether what is the any transfer pricing involved, any royalty, or all these things. When it is sometimes this could be very disproportionate to the operations. So in such cases, then we have to be very clear. Then we have to build up a case. You get a suspicion based on this, then you have to find more information. Then there could be instances where already one forensic audit has been conducted by one bank or the other. During the course, suppose the case CAIRP has started much later after the account has become sick, maybe 5-6 years later. Then you need to see whether already some exercise would have been done. If there was any forensic audit earlier, the very conduct of such earlier forensic audits is a red flag. Why a forensic audit has been conducted? That itself is a cause, something which we need to explore. The specific circumstances of conducting such an audit is to be seen. Those reports have to be collected and reviewed. So we need to see, like, if there is a forensic audit already, then suppose, then we need to see, and then we have to ask more. Then we probably will call that auditor and discuss more. And then we'll discuss with the statutory auditor what exactly is happening. Forensic audit reports may have not been conclusive due to non-submission of data to the audit agency. This is another important. Even in our case, it might happen. You engage a forensic auditor and he gives with all report with a disclaimer saying that I did not get this register, that register, so many information which I asked for 5 years data, I got only 2 years data. All these things question come up. So the earlier forensic audit report has remained unconclusive because of such things. Then we know that something is definitely wrong. So we need to dig more deeper. Then connected entities. This is a very big red flag. But suppose you have a corporate debtor and then you find that there are some subsidiaries and associate concerns, and then the promoter has doing business in several areas, several industries. Then there is definitely a scope for misuse of funds. The presence of a large number of related connected entities to the company is also a red flag. So you can find from MCA data, you go to the director's DIN number, take the director's DIN number, and then check how many companies is the director, how many companies is associated with. All these things you can get. And once you know the name of the company, you go and check what are the financials of that company, whatever information is available in the MCA data, MCA site. So once you know the connected entities, you will be in a better position to understand. Then once you know there could be a relation between, suppose the director is common, then you need to see what is the nature of investment in these entities, what is the how exactly the relationship has developed. And then you see what are the audit observations in that Suppose statutory auditor says that the company has invested in this company, there's so much then you see what is the value, what is the thing, and whether it is required, not required. And also you need to see whether any interest-free transactions or any book entries as reported by auditors has happened. So if that such thing is there, then it is a red flag. Then we need to. So basically, these things are listed out just to understand that there could be other. You need to look into that and see how exactly we need to proceed. And then even in the balance sheets, you will have related party transactions. Most of the audited balance sheets have this. So you examine those related party transactions whenever there is a related party. Then you have to summarize them to examine the quantum of such transactions. How much has money moved from one firm to another firm, another company, and then whether is there anything irregular that we need to see. Then suppose in foreign locations, there is a subsidiary which has been formed in the foreign location. Most of the companies have their another office in US or Europe or something like that. And then all these things we need to see whether how the money is being moved there. When all investments, purchases, sales, loan transactions, everything needs to be seen. Any report of FEMA non-compliances. Suppose there is a foreign unit, foreign connection is there, then you see whether form non-compliance of FEMA guidelines are there, because mostly if something irregular is happening, definitely one guideline or the other would be violated. Then interstate movement of funds between the bank accounts, that you examine. Diversion of funds, whether you are able to identify, that you see. If you are able to identify diversion of funds, straight away you can build a case for fraudulent transactions. So connected entities is a very major item which you need to very specially see. And then even commented items, you have what you call special purpose vehicles. Now most of these real estate companies are having all this for each project they have an SPV. But you will see that there are some real estate companies, sales are done in the holding company, expenses are done in the SPV. So you will be like, some money is coming, money is collected in the SPV's name, but then expenditure is done in the holding company. So which is profitable, which is not profitable, which is how exactly the money has been utilized. All these things come into question. Then you find that there is a SPV, foreign SPV has been closed. You set up a unit, you take approval and all that, RBI's approval is required, everything is done, and then you close it, and then you don't submit the reports. Then there is something wrong, because the money which has gone to abroad location, whether it has come back, whether how exactly it is done, all these things raise questions. No return on investments in terms of dividends or refund of capital even after a long period of time. So once you find that there is a subsidiary which has been created, whether it has made profits, when dividends have been given. So this is a very relevant question you should be asking. How exactly this is happening? Then most of the times what happens in foreign locations, you say some loss is there or something like that, it is unviable, and then they close it. And they write off the investment. Large investments extinguished or written off and recorded as losses without proper rationale and eroding the net worth, shareholding, diluted by the fraudulent and collusive right issues process and relinquishments by the CD. These are all the things which are listed out by IBBA as red flags, which we should look for in case of special purpose vehicles. Then one more aspect is that there are some action taken by the regulatory authorities. So non-registration of the corporate debtor. connected entities with GST or IT authorities, and non-filing of mandated returns. Returns are not filed, monthly returns are not filed, and then quarterly, whatever is required is pending. PF is not deposited. Then there is some notices. Then there is dispute, high value disputed and undisputed statutory dues of the company. It is appearing in the balance sheet, and you find that some notices are there. Some cases have been filed. Any cases filed by the regulatory authorities such as SEBI, SF5O, Police, CBI, RBI, FEMA, all these agencies are there. And if there is any notice or any question you find during the course of your initial study of the corporate data, then these are all red flags. Then you need to engage a transaction auditor and ask him to look deep into this. So all these things. And then one more thing which you need to see is that if a legal counsel, repeatedly, there are so many cases, pending legal cases are there and legal counsels are there, and how much money is spent on legal counsel, that would give you an indication of how much, what do you call it, irregularity is there. Now, suppose you are paying 1 crore to somebody, then you are trying to protect maybe to some extent of 30 crores, 40 crores, 50 crores, whatever amount. So that gives an indication. What is the payment made to the legal counsel? These are what I just highlighted is the entity level red flags. Now, because it could be auditors, it could be regulatory authorities, and then it should be the basic nature of the industry. You need to see all these things. Basically, once you know what kind of industry it is there and what actions have been taken by the different people, stakeholders, then you know what are the items which you need to pursue. Then we will move on to what are called component level red flags. Component level red flags, that is, you see, these are all possible when you have the balance sheet. Latest balance sheet is there, then you are able to see. And then so there are different ways of analyzing the balance sheet. You list out 3 years balance sheets and see how it is coming, how it is going, where the funds are going, funds are coming, any sudden increase is there, sudden decrease is there on a particular component. Then you will know that these are all the items which you need to see. Now, what are the component level red flags? Fixed assets and inventories. Fixed register, we need to study closely whether you need to take control of all the fixed assets, whether they are there, and then you know if any stocks or any fixed asset is missing, then it is a clear case of fraud. Then the director has to explain where the asset has gone, whether he has sold it off, if sold, where the money has gone, all these things. RP to analyze the fixed asset register and earlier physical verification reports, if any, as well as CARO non-compliances. CARO report is especially physical with regard to assets, what are there, what are not there, and all that. So physical verification needs to be done, and the statutory auditor might have done some verification of stocks, or some bankers would have done. So all this, try to get the reports. If you find that some fixed assets are not available, then you need to see where they have gone, at what point of time they have gone, and that you try to get the information from the bankers also. Then another aspect is high value inventory, not verified by the auditor, but certified by the management. Why this is very significant? Because the value could be inflated very easily. And once you inflate the value of a sundry, this inventory and all that, then you can easily show lesser profits. And so the money is slowly, then after some time you say sundry data, this inventory is not usable. This is, you say it is waste or something old or something like that, and then you can write it off. So there is something wrong going on. Then if you find that sundry debtors, you find that there is no recovery, there is no action taken, Then you check with the auditor. What auditor is saying about the recoverability of these advances. Suppose they say it is pending for more than 6 months and not likely to be recovered. Then you need to see more closely. Any high value item is there, and who is the person who is not paying, whether that is a related party. If it is a related party, what are the terms of the agreement? Whether the item has been supplied or shown to be supplied at a higher rate, normal rate. All these things create doubts. Then there are situations where you are not able to get confirmation from the sundry debtors. The receivables are not confirmed. You are in the balance sheet, you are saying X and Y has to pay 5 crores, but you don't get a balance confirmation. When you write to them, they don't reply, or they say that no, there is some dispute. So these are all like, this is like our Sherlock Holmes should get immediately alerted where the money is going. Confirmation of balance is not obtainable by the auditors. Receivables, payables, and loans and advances, although they are material sums. So a lot of money is involved, but then there is no accounting for it. What is the problem? So this is fixed assets and inventories. This is a very major item where a lot of irregularities take place. And then we need to be very cautious because they are physical. If it is there, if it is not there, then very clearly it is something wrong. And then as far as fixed assets, there are other aspects. There are 3-4 units, all associate concerns. The assets of the CD are being used by the other entities. So there is no proper accounting. You use the machine, but then whether you pay for it or whether any proper agreement is there, or whether simply they are using it as a free of cost. And then what is the charge? And then all this is another aspect which is quite common, which we need to see. Then sale and leaseback transactions, if it is happening, why it is happening, where the money is coming, where the money is going, by raising a leaseback. So you are trying to get back the asset, keep the asset as well as get some funds raised, and then that becomes where the funds are getting utilized. Unauthorized creation of security interests, fictitious purchases of goods and services. Very important item. Security interest you create, but then the corresponding loan is not there. Then large sale of assets, undervalued sale of assets without valuation reports, competitive sale process. All these things are, if you are able to see, as far as fixed assets and inventories are concerned, there is something wrong. Then inventories are there, but no records is there. Record is not maintained. But there is no stock register. There is no, over a period, what are the stocks, what are coming in, what are going in, where the coming. All these records are not maintained. Hence, complete loss of visibility. And massive write-offs are provisions for inventories. Write-offs are there. Undervalued and alienation of sale of inventories and funds related. So all these things create a lot of doubts in the minds of people. Then we need to try to find a related document, where we can fix the responsibility.
Sir, I have one query.
Yes, sir.
Yes, sir. Sir, in most of the cases, no, books of accounts are not available, sir. And due to date, this assets register and other things we are unable to verify.
Yeah.
Then without date, sir, what are the options with us for PUFE transactions? Because books of accounts in many cases not available. Or
Books
either promoter don't want to give. These things are happening. So in such a scenario, how we have to deal with it, sir?
See, suppose you are talking about inventories, then you see whether any stock statement has been submitted to the bank. You try to collect the copies of stock statements which has given to the banker. So that
Okay.
that you produce before the promoter and say you are given this stock. So that stock and then you see, and there is suppose there is some what you call export is there, and then you know whether export has taken place, and then related production you need to see export, the realization of export has happened. Suppose the realization has not happened, then some export bill has gone. So the question is whether actually export has taken place, what they have sent. So there are related things mostly from bankers. We try to collect the information, and other people, suppose sundry data is write to them, and they come back and say that we never like we have to pay nothing to them. They have already paid. So apart from the books of the bank, any related parties, any other stakeholders who can give some information we need to see, because it is very difficult to, as you say, once you don't have a books, then where is the question of analysis?
Yeah, that's why I'm telling, because even from the third party, we can just check the documents. But until and unless we are unable to verify the books, what the treatment they are given in the books,
Yeah,
then also it's a difficult to that.
I understand, very difficult, and
Yes, sir.
you cannot
Because you know
compare.
that NCLT is normally not accepting any application, and they are going into deep.
Very true, very true. That's a genuine problem, which because
So because if you see, sir, most of the cases are pending in the bench level, and very few cases are accepted.
yeah. I genuinely, I mean, agree with you in the sense that it's not easy. Suppose you don't have any basis at all, and then
Because if we are going for this section 66 application for fraudulent, then their criminal activities are also involved. Then we have to file the separate application. So in this case, bench are also means many things are there, sir, to means accept those application by the bench.
yeah, I fully agree. It is not, see, so many things we can see, but then ultimately, how we need to file an application, because before the court you cannot simply write an essay and say this is
Yeah, yeah. That's why I'm telling that before filing an application, means
Hmm.
what are the evidence as per your view or suggestion that we should have, then it will be been beneficial and easier for the court to accept the application.
See, basically, that's what. See, there are so many items which we can look at. See, basically, it depends to depend on a particular case.
Yeah, yeah. It's a. I also agree. It's a depend upon the particular case, but in normal, just I'm just saying, sir.
That's what. See, so many things we are talking about. Suppose I'm saying fixed assets. What are the fixed assets? What are the different aspects we need to see? We are saying whether when it is purchased, how it is purchased, whether it actually it has moved, it is there, and many data has been given to any bank. So all these different things are to be seen, but the ultimately basically see, you cannot recreate the past as an RP, because you also have a limited time. So whatever time you have, whatever the circumstances, whatever the resources you have, within that you try to build up a case. But ultimately, see, the point is the creditors are also have to support. No, they have to give the loan. They have given the loan, and they are also they have some information. They have managed the account much better, because as an RP, you come at a very late stage where they have been
Yes.
associated with the corporate debtor for long period. So all these things they have to support. It is not that RP can do wonders. There is no magic wand for this. So we have to do. So, but only thing is, what we need to satisfy ourselves, whether we have explored all the avenues, whether any possible way is there, we can get some information. Either something is filed, and suppose how exactly. So the correlation we need to see. Suppose some sale has happened, of course there will be an invoice, and suppose there will be some movement of goods. So we have record of movement of goods, whether we have a record of actually filing a GST return, whether what it tallies that. So different aspects, connected items we keep looking at, and then try to build up a case. And after 5 years, 6 years, you may not get the data also. Suppose generally we come across CDs which are, the balance, the unit is closed in 2013, 2000.
Yeah, it's a true, sir.
So I fully understand. It is only thing is, when I go through all the red flags and all that, what the impression I get is that, okay, you just because unit is closed, 5 years have done, don't give up. You see different aspects, different angles. You see whether it is possible to get any clue, any something at all. We see to fix that. And initially, as I said, suppose no balance sheet is filed, then we can, that itself is a case, is a fraudulent activity, because a company has to file a balance sheet as per Companies Act, and then we can go and question the auditor what he has done or what he has not done, whether he has pointed out anything. So different ways of, see, there is no clear-cut answer, because it's basically it's a company closed for a long time, so 7 years, 8 years, and all that. It is very difficult to get the information. But the purpose is that, as an RP, what you can do, whether you have done.
Yeah, got it. Thank you.
So now, inventories, we have so many other cases where basically large inventories are there, inflated stocks, is book dates reporting without any underlying. See, inventories used for personal. These are all, very difficult to find in books also. Suppose there is a different, there's a allied unit which is using the machinery, which is using the stocks, and then they don't pay for it. So these are all cases which you have to, clues which you have to look at. And then stocks are inflated and book debts are inflated. So this is what regularly, most of the times, it done in banks. They give a stock statement or receivable statement which is lying, and you compare 5 or 6 month statements, same things are repeated. So which clearly that there is no movement. Either the unit is stopped, or it is not working, and they are simply trying to enjoy the funds without any actual activity. Then when you look at sundry receivables, payables, advances, etc., then again same thing, confirmation of balances, whether it is there, auditors' comments are there, whether payment to vendors directly by customers. This is another thing which you may have to see, whether without accounting, they are asking the customer to pay the payment directly to the raw material supplier. If that is happening, there is something wrong. There is some accounting, there is some differences there, which you need to look at. And then significant cash transactions undertaken by the entity, and possibility of certain claims also to have been admitted based on cash transactions. Nowadays, a lot of restrictions are there in cash transactions, but in spite of that, this happens very, especially, I can think of cases which have handled this iron scrap, steel scrap, and all that. Iron scrap used to be there. There used to be no accounting. You simply take the money, and then one slip of paper, they say it's so many kilos and all that, and it goes on. And then real estate, how much of sand is going on, how much of other material, very difficult to pin down. A lot of transactions. So that is what IBB says, that when there is a real estate business or infra business or some power business, there is very high scope for fraudulent activity. Or hotels, if you say hotels, what happens is hotels, they say 80% occupancy and all that. There may not be people, but they try to convert black money into white into this showing as receipts. So a lot of irregularities take place. So when the unit has gone bad, it is very, very possible that something irregular has happened. It is not possible that it is that you take the money and you do genuine business, and then nothing irregular could be found. One more aspect is that bank guarantees. Sometimes bank guarantees are there, performance guarantees are taken for supply of material. And then, or sometimes bank guarantees are taken as general as a dealers, they give guarantees and all that. Suppose there is an invocation of a bank guarantee, and that becomes a what you call a funded loan. Because guarantee, you are not able to meet the liability under the guarantee, then it becomes a loan. Then what are the terms? Why it has happened? This is the red flag which we need to look into. Then another aspect which we need to see in the financial statements is revenues and receivables, fraudulent accounting, reporting of sales and inflation of receivables. Why this happens? Most probably this happens because they want to tell the bank that there is a 20% growth and they want increase in the limit. And then the money is taken for working capital, and then some diversion happens. Actual accounting and bank accounting, most of the times it becomes variance. Then customer payments are made directly to vendors, promoters. Promoters are taking money from the customers. And receivable balances are shown as outstanding. In the books, it is shown as outstanding, but when you go on actually, the sundry debtor says, I have already paid to the director. So which means that it is directly affecting the financial lender, because his money is there, but money has been taken away. Large receivables extinguished, written off, and recorded as losses without proper rationale and legal efforts, and eroding the net worth. So all these balance sheet manipulations, fictitious bank receipts. It is there in the bank book, it is in the book, but it is not appearing in the bank statements. So which means that if you do the banker's reconciliation, you will find that what is appearing in the bank account is not appearing in the bank statement. Something fictitious happened. Sudden increase in unbilled revenue. Why sudden increase in unbilled revenue is a red flag? Because you are showing that the increase is there, but you are not billing it. Why? There is something wrong. Some money is getting diverted. Undervaluation of sales. So again, this is another way where money is taken out. Then when you go and see the loans and advances part, then you would find that corporate debtor has given loans to so many people. Loans and advances given without any agreement or legal recourse. There is no promissory note or any agreement or loan agreement is there, but it is appearing, somebody's name is appearing as that they have taken a loan. So where the money has gone? Loans to directors, entities, and for no business purpose, and includes related and connected entities. This is a very common way of moving the money. So director takes loan, or his joint venture, or some other person takes a loan. Loans and advances on an interest-free basis, although interest is paid by the CD. The interest is paid by the CD in the sense that they are taking a working capital loan and they're paying for it, and that money is lent to somebody else on interest-free basis. This happens regularly. Why? Then large loans and advances written off without any legal recourse, attempts to collect, and eroding the net worth. So why this is happening? Because he is your friend or somebody, you are not taking effort to, you don't send a notice, you don't file a legal complaint or anything like that, you don't file a case, and then after some time you write it up. Then loans and advances balances outstanding in the strike of entities, and no proceedings are possible. This is another item which has been shown as a red flag. That is, the entity itself is not there, but your books continue to show that the money is to be received from this. Then absolutely no issues, no recourse is possible, because the entity itself is a stricken off entity. So as far as loans and advances, these are some of the things which could go wrong that we need to look at. Then another item called share capital or premium and how their utilization. Share capital is shown in the balance sheet, but you find that it has not come, it has been routed through bank. Some adjustment entries have taken place. Suddenly, you saw that some so-and-so promoter has brought in capital, but there is no entry at all. So how the money has come in, nobody knows. Or only book entries is there for the capital. Or sometimes what happens, share is valued at a very high premium. Then, which means that who is valuing the share, how the valuation is there, because this is another mode of diversion of the money funds. Shareholding is fictitious. Shareholders have themselves extinguished the investments in their balance sheets. Then company funds have been used to purchase shares of company by directors. So company, the director has increased his amount, but he has taken funds of the corporate debtor instead of bringing his own funds to increase the capital. These are all red flags. So when you have a balance sheet, basically we should have a checklist of things like, for each item we need to see whether something is wrong, you are able to get any clue as to this has happened. Then you form an opinion. Well, you find that none of these items are there. Then you come to a conclusion that there is nothing irregular which has happened. Loan transactions, loans recorded by mere book entries. Again, we just discussed without money coming in or going out, loan is appearing. Then loans taken without no objection. Round tripping is a similar thing. Loans taken without no objection from existing lenders. So, of course, bankers would put a condition saying that you cannot take a loan, and even if you take a loan, our loan would have a higher priority and all that. But they definitely would ask for information. But sometimes only in the balance sheet it appears, and then you take a loan, and then what you did with that loan, because working capital has been sanctioned by the banker, and then whatever asset you are taking a loan, or you know already capital is brought in, then what purpose you are taking another loan? That needs to be explained. Unsecured loans becomes a secured loan without a new value. We discussed this, you take a loan, it becomes, you give some security interest. To one bank is giving a Section 138 notice, they are saying that we'll file a criminal complaint. The director immediately say, okay, this property is there, you take this property and keep with you. What happens? That particular creditor will get, he will become a secured creditor, and then his benefit is there. And this is precisely what is defined in the preferential transaction. And secured creditor becomes a secured creditor. So when the distribution takes place and waterfall mechanism, he gets a priority. Certain loans are settled in priority over some other loans. This also I gave an example where you pay off the loan of somebody, some director's loan or related party loan. Then you sense that there is something wrong because they are paying out, and after some time, the loans of the bankers will get stuck. Loans stated as received in cash loans received exorbitant rates of interest. We discussed this. Stated as secure loan by unregistered MOD and antedated transactions. So you create a loan in the books. You say that I have given this mortgage and all that, but where is the proof for the mortgage? There is no registered mortgage. There is simply just that one paper is signed, maybe backdated. So it is just to build up some facade. Where loans have been recognized due to invocation of bank guarantees, where such BG did not reflect genuine business transaction. This is a very clever way of doing it, that you take a loan, take a bank guarantee for something, then after some time bank guarantee becomes, invoked. And then your bank is saddled with this amount. Bank guarantee thing, they get maybe 1%, 1.5% bank commission, the guarantee commission. But then when it becomes invoked, then it is a loan, unsanctioned loan. So that becomes a problem for the bank. So these are some of the things. So basically, there are so many items which we have discussed. So there is no end to this. Basically, once you have a balance sheet and then you have a habit of analyzing the balance sheets, then most of the people are chartered accountants here, and they know when they have a look at the balance sheet, they'll know, okay, something is wrong. And then there is a systematic way of comparing the balance sheets over a period, 3 years, 4 years, 5 years. And then you know where is the movement. And then there are other, what is called vertical analysis. You convert all the items into percentages. Then you see, compare over a period, whether suppose the current ratio or the items current ratio to current assets to liabilities, the same percentage there. And then whether where exactly the money has come, whether any particular division is spending more, whether a particular division is getting subsidized by other profitable businesses. So all these things can be seen. And then basically it's a question of analysis, and it's a question of doing some investigative work. Whether you have time, whether you have the data, all these things for that is a difficult process. That is difficult to answer. You cannot answer now. But only thing, as I said earlier also, is that you try to find as many clues as possible, and then try to see whether something is really you can make out a case. Once you do that, if a case is built up and then there's some money is recovered, that's really a great job by the resolution professional. In fact, I was reading one of the articles of Mr. Sahu, the earlier IBBA chairman. He was talking about this preferential transactions, what action is needed.
डाइनिंग तो दे दो 4:30 बजे खा लियो अबे 1 घंटे का ब्रेक भी तो होएगा अभी भाई तो रजाई में बैठ के खाएंगे वो रजाई में तो लगते हैं सारे झूठे यार तू तो सो जाएगा मैं तो उधर जाऊंगी तो रजाई में मत बैठ के खाइयो
So now I was talking about these things that you try to identify and then see where exactly some lacuna is there and try to build up a case. That is where, of course, basically our job is to see that RP is expected to say that something is wrong somewhere. Then you can ask for an expert to sit there, and you have an auditor to specifically look into those aspects and build up a case. That is the purpose. So the analysis is basically for us to get a broader opinion. And then there are so many red flags which I have listed out, and then with specific reference to inventory, fixed assets, and all that. So many things we have discussed. Basically, it's the awareness has to be built. So you go through these things, red flags, once or twice, or a period of time, when you say one thing may be applicable for one case and another thing may be applicable for another case. But the awareness is what is, I think, required. That is what is expected from the IBBI, that RP knows these aspects where something can go wrong, and then he takes action. It is possible that action may not be foolproof and it may not result, but then, as I told you, it is not that you just Just because you don't get a result, it is not that you don't take action at all. You have to see what action can be taken and what transactions can be identified, and then make a sincere effort to file an application for avoidance. So now we'll move on to the next topic. Some basic things which are basically some discussion we'll do about what is a transaction audit and what is a forensic audit, what is expected from them, and how they are to be appointed and all that. So now let me first talk about a transaction auditor. Transaction audit is with the specific reference to this PUFE or PUFE transactions. So when you find some transactions are there, some like, sale has happened, or some diversion has happened, and not a security interest has been released, or some heavy loans have interest have been paid, and heavy loans undervalue transactions are there. Something you see, then you decide that you go to the COC and say, look, there are some suspicious transactions which I think require more analysis and more investigation. So I need a transaction auditor. And as far as PUFE transactions are concerned, it is the transaction audit which is to be done. Forensic audit is what? Forensic audit is a much broader thing, which is done by our lenders basically. If the lenders see that there is some diversion of funds, some fraudulent activities there, then they appoint a forensic audit to find out more into the modus operandi and how the money has gone, what is the tracking, how the money is to be treated, and there are other things. You see, basically, the role of RP is to see what is called in the avoiding transactions. There are two things. One is recuperative. You try to recover. That is the focus of the RP. There could be other culpable activities. There could be fraud. There could be we were discussing about fictitious statements given and all that. There, I think more involvement would be of the creditors. So they want to fix it because they have to report as a fraud. And the RBI requires that if you find something irregular, then you have to report a fraud, and there are specific guidelines for reporting of fraud, and then a bank is expected to do that. And for doing that, they go for a forensic audit and then clear what exactly is there. So we are more, as an RP, you are more concerned with a transaction audit. Then, so some aspects about transaction audit, let us discuss here. Transaction audit may not be required in every case. Yes, because RP has to form an opinion, he has to file an avoidance application. He takes the support of the transaction auditor, but it is not necessary that without a transaction audit, you cannot file avoidance application. It is not like that. You cannot do that. You suppose very clearly you see that some property has been sold, some asset is not there. You go to a factory and say that a big machinery which is worth a few crores of rupees, it is not there. Then you don't require an auditor to say that. You give a notice to the director and say, where is this machinery? And then one or two notices you give, and then you give a telling that we conclude that you have unauthorizedly sold this machinery, and then you file for avoidance. You say that RP, this promoter has to compensate. So it is not required that transaction audit has to take place in every case. That is broadly said. But for all practical purposes, RPs go for transaction audit because it is possible that something you might miss. And as an RP, you are dealing with so many other things. It is not possible for you to sit and do it yourself. But when RP has to look for a transaction auditor, the RP may consider the following factors while deciding whether it is appropriate to conduct a transaction audit. What are the things? How large the company is and how large the group is. Okay. The complexity of the business of the corporate debtor. whether a sophisticated business model. It is suppose they are doing some investments and some losses have occurred in this, options and derivatives and all that. Then it is very difficult for you to pin down. Or some software they are doing, and then some losses have occurred in the software development. Some write-off is happening in a pharma company. They are saying so that some research we have done and we are not able to get a result. We are closing it. So such things are there. Then you need more expertise to study that. Then RP may not himself be well versed with the industry and the various lines of businesses of the corporate data. If you're not very clear, because there could be a complex business, then you try to appoint somebody. And then the number of transactions. If there are a large number of transactions over a period of that, there could some difficulty is there and understand. And then sweep of such transactions. Then whether it is with entities, associate concerns, some suppliers, foreign, abroad, SPVs and all that, then you have to understand better. For that, you require an auditor. Then you also see what is the relative costs. What is the, suppose you, how costly the audit is going to be, and what is the litigation cost also. Okay, ultimately you found something and then litigation is going to drag on so much that you are not able to get, there's no point in doing this. In that case also you need to take a call. Then liquidator's RP's self-assessment as to whether the evidence collected by him will be sufficient to make a good case. As I said, something is very obvious that you don't require an auditor to certify. Then you can, if you are very clear that this is there, then you go and file an application. So these are the things when you, on what basis you file you appoint a transaction auditor. Then some basic differences, as I told you, transaction is with reference to specific transactions. Transaction audit may not be required in any case. And then transaction audit is to determine existence of any of the categories. Like all the 6 categories we discussed, 4 plus within that, then wrongful trading and all that I've listed out here in the slide. Differential transactions, undervalued, transaction defrauding creditors, extortionate transactions, wrongful trading. So all these things specifically you notice, and then you try to get more information on that. You require a transaction auditor. Then even this is also required to meet your responsibility as an RP that you have to see. Then, as I told you, forensic audit is much more broad-based, and then it is a wide scope of work, and that includes end use of funds made available to the corporate debtor. It is not a transaction-specific thing. It is a much broader thing. And forensic audit is conducted by the lenders at their cost. This is what is mentioned in IBBA's thing. And what I find is most of the times a transaction audit and forensic audit get mixed up, and then they call a forensic audit, but mostly it is with reference to this PUFE transactions. So if something is totally unrelated to preferential these under avoidance transactions, then it should be at the cost of the creditors. Then it will not form part of the what we call CAIIB cost. Then it is a much broad way, so you need more information is required for this forensic auditor, and then we have to see. So now there are some more aspects which are mentioned, which reference to transaction audit, which I would like to highlight. These are some of the things which are mentioned in the IBBA note, which says that RP cannot charge separate fees for determination of avoidance transactions and for filing of the avoidance application. Most of the people, I think nobody does that. I've not heard of any RP charging separately for this, but it is specifically mentioned that it is part of the RP's job. The professional fee he receives covers the entire work. Then second thing is, again, is emphasized here is that COC has no role in determination of the existence of PUFE transactions. it is the responsibility of the IRP or RP. The RP liquidator cannot himself be the professional who conducts the audit. Again, this is laid down specifically saying that just because you don't want to appoint an auditor, you say you give a report, transaction audit report, and says that you pay separately for that. That is not done. You cannot be an auditor yourself. Then section 28, which specifies actions which require approval of the COC. Basically, what we are saying is that it is the RP has the authority to appoint the transaction auditor. You don't require an approval of the COC. Why you don't require? Because section 28 specifies which are the actions which require the approval of the COC. And there is no mention of appointment of professionals in section 28. But in section 20, which lists out the roles and responsibilities of RP, this is mentioned that he can engage professionals and he can engage, give assignments and all that. So he can engage that, but he need not take the approval of the COC. That is the position. But one thing he has to ensure is that the fees charged by the professional is reasonable and it is proportionate to the work involved. Then the findings of the transaction audit may be discussed in the COC meeting. So always this question comes up, then you say that COC members would ask, okay, you have appointed a transaction auditor, where is the report? And we want to discuss that. We want to take a call because we have paid the fee and all that. So you need to discuss, you need to present the audit report. It has to be discussed, but same should not be a voting agenda. So there is no question of taking a vote, whether you will file an avoidance application. COC, because COC is not involved and COC RP has the powers to file an application and RP has to do it. So you don't present as an agenda item before COC and say, take a vote. And suppose COC decides that let us not file an avoidance application. It is not possible that you will not do it. If COC member has any views on the matter, on a particular aspect of the transaction audit, the RP shall record them and thereafter go ahead with the filing of the application. So in COC minutes, you require all these things. So you record and say that so-and-so said this and all that. But in spite of that, suppose you say there is no use, like, everybody's we commonly say that what is the point in filing a avoidance application? It is not going to be taken up, or it is going to get delayed, or my resolution plan will get delayed, or approval of resolution plan might get delayed. All these concerns will come. But then all these things you may note, but then filing an avoidance application, if you feel as an RP, you have taken an independent decision, you have come to a conclusion that there is the PUFE transaction, and you have to file an application, irrespective of whether what the COC approves things or whatever that but you need to record those things. The cases where COC is not cooperative and does not ratify the fees of legal counsels, advocates, and other professionals. This also happens quite commonly, saying that, okay, no, our COC says already, what is the point? We are not getting any recovery, so why I should file an application? In that case, the RP has a duty to file an application, whereas he does not have the money, he is not getting the support. So in that case, what he has to do is he has to record all the deliberations in the COC minutes and then file an application with adjudicating authority seeking directions. You may not be in a position to file an avoidance application, but you seek directions from the court. Then this question came up earlier, somebody was asking whether liquidator RP shall not be held liable for not being able to discover and unfold certain transactions. So you make all your efforts and then you find that nothing concrete could be found. In that case, the professional conducting the audit could not unfold by way of a reasonable assessment. Then if the action of the RP and the professional and all that is genuine and it is there, then there is a protection. There is an indemnity under Section 233 of the code. Section 233 says that indemnity will be available for all the genuine actions. I just read the section. I was talking about this. So not only RP, all the people are indemnified. The IBBI, the officer, the NCLT members, other employees of the board, insolvency professional, liquidator, all these people are protected if they have for action any taken in good faith. So there is a good amount spent on transaction audit or forensic audit, and ultimately nothing comes up. So nobody can blame saying that RP has not done his action, RP has failed or something like that. Because if you have done in good faith, and the Section 233 gives a protection. Then what are the other things? Let me see. Then once this transaction audit report comes, the basic idea of getting a report is that you have to file an application, and file an application that too successfully. So like we had discussed, just some of our things sir was asking, like, you know, if transaction audit doesn't give a proper report, then so we need to compare the scope of the audit with the findings. So what if the scope of the scope has been understood properly by the auditor, and he has done all the things, and then complete examination has been done, and in spite of that it is not there. Maybe you find that some scope he is not getting the data. You try to get that data and give it to him, or he is not getting old records. So in that case, you might give a disclaimer. So we are then basically our idea is to file the application and how better. So when you analyze the transaction audit report or a forensic audit report, the basic idea is how this report is going to support in filing the application. That is the idea. And if it is not supporting, then you go back to the auditor and ask more, you raise some queries and ask them, and then you try to get some clarifications. And then based on additional data, you try to ask them to give a supplementary report. So these kind of things which we can do. And then we need to be very cautious about the disclaimers in the audit report. Most of the times there are several people who don't come to a conclusion. They'll simply say that 1, 2, 3 disclaimers are there. Because of that, I will not give a report. So again, you need to discuss and then come to a conclusion how it is going to help on all. Then one more important aspect is this quantification of the irregularity. So whatever qualifications you find, it needs to be quantified. Then only you can file an avoidance application saying that there's a loss of maybe 1 crore, 2 crores, 20 crores. If you are not able to quantify that, and if the audit report is not supporting in quantification, then merely saying that something went wrong is not going to help at all. That is the problem. So you need to analyze the report in the direction of getting a quantification. So these are some of the things which are important, which I've discussed with people. And then I'll leave the floor open to questions.
Sir, I have a question.
Yeah.
Sir, in a case where, say, transaction audit was conducted and
Yeah.
Financial transactions, and then the RP accordingly filed an application in the NCLT, and eventually the NCLT was of the opinion that passed to judgment that there is no preferential transaction made out, and it is in the ordinary course of business. So is the RP supposed to file an appeal? Is there a provision for an appeal under IBC?
Appeal can be filed basically if you are basically appeal can be filed by somebody who is the what do you call who is the losing party, that you have lost something because the order is there, you are not able to get a beneficial order, then you file an appeal. And if your avoidance application is strong, and then the NCLT bench has not taken so many things into account, maybe there is a scope for appeal. But always the question comes is, who is going to bear the cost of the appeal? Now, whether you need to convince COC first, whether they'll bear the cost, because you as an RP, you are not going to bear the cost. So you have to be very careful. And if there is definitely a case, you are very confident that the very significant findings have not been taken into account by the NCLT, maybe there is always a case to file an appeal.
Okay, sir. Okay.
Sir, here I have a say. I think there is recently or some time back there's a judgment which says that I think NCLAT or somebody has held that RP cannot appeal against any orders against him, except where he is personally affected.
Yes, sir.
So
Yes, sir.
if an order is passed against the CD he is representing as an RP, they say that he cannot file. Suggestion is that instead of RP filing, let the COC go and file an appeal.
Just I referred, sir. That's what I said. You need to convince the COC that there is
The COC should be the party, sir, not the RP. Also,
Yes,
COC should file because
Yes,
they
sir.
are the people, financial creditors who are going to be affected by that. I think that's how we overcome this judgment which says that RPs can't file an appeal.
But sir, in this scenario also, whether because nowadays the benches are saying that you need to have some provision under which you are filing it. So in that scenario, an appeal, if it is filed by the COC also, whether is there a provision under IBC, specific provision?
The provision is the same thing, which our normally where appeal is filed, section 61 or 62 or whatever, that appeal. See, basically, what I meant was that, if COC feels that the order is against their interests, they are suffering because of this order, and they have valid grounds to question the order, then they should file an appeal. So the order is the same appeal section is there, section 61, if I'm not wrong.
But one thing, though I suggested it, as an advocate, I feel there will be a technical ground on which the parties to the application only can file an appeal. Who is the party to the application here? RP versus the corporate debtor, what you call ex-promoters and all. In all PUFE transactions, the respondents are the erstwhile directors or the beneficiaries.
Exactly.
Now, in case of an appeal, only the parties to the initial application can only file an appeal. So if RP can't file, I don't know how somebody can overcome that. That's a question which needs to be really considered and looked into. Because COC is not a party to the PUFE transactions, because the petitioner is the RP and the respondents are the others. And if the petitioner wants to go back to the court and RP is prohibited from appealing, then I don't know. Maybe somebody in the audience can say, or if Mr. Raghuram can clarify on that, I will be happy.
Narayanji, this is the judgment of the Supreme Court recently, which you are quoting.
Yes.
This is judgment of Supreme Court.
Yes.
Whereby it was directed that RP cannot file any appeal. Either the COC or the other persons should prepare an appeal.
Sir, COC is not a party in your application. How can they file an appeal, sir? In that case, when you are filing as a petitioner, the petitioner has to be the COC,
It was
not
stated
RP.
in the matter of reason Giriraj Enterprises. It is in the matter of reason Powertech versus Giriraj Enterprises.
Which means that CD is appealing.
In that matter, it has been held that Supreme Court has said RP do not have power, resolution official do not have authority to file appeals. RP should have maintained a neutral stand. It is for the aggrieved parties, including COC and CD, to take appropriate proceedings or file an appeal before the court. This is what has been said in that matter by the Supreme Court.
I got your point, sir. Here, in that case, then PUFE transaction should not, the petitioner should not be the RP, it should be the CD and represented by RP. Then the CD can file an appeal.
Yes, sir. Yes.
CD
Absolutely.
is, sir, CD is the one who who led to the PUFE transaction. He is the originator of the PUFE transaction. How he can file an appeal against his own conduct?
No, sir. He is the loser. He is not CD. He is the loser. The activities are conducted by somebody else. They are erstwhile directors. Here in PUFE transaction, CD is never made a respondent. It is only the erstwhile directors and beneficiaries are made a respondent. Therefore, CD can say this money should come back to the company. And CD per se can file an appeal on behalf of whoever can appoint this, whoever can represent the CD.
IRP in the capacity of RP of the CD, he can file an appeal.
It is only technical, sir. It's only technical.
Sir, after all, sir, after initiation of CIRP, CD is always represented by RP.
That's what, sir. This cause title of the case should be not RP versus. You mentioned CD versus CD represented by RP. See, most of us make that mistake where we make RP as the petitioner.
Yes.
Instead, you say CD represented by RP as a petitioner.
Got it, sir. Got it.
Got it, sir. And I think it's a general thing, sir. Generally speaking, RP, because in the light of this direction, RP cannot personally make a petition. He has to. In all
That's
cases,
what, sir.
like
RP in a representative capacity can make. RP is not the appellant there. CD is the appellant. He is representing the CD. That's all.
Yes, sir. Yes, sir. Correct.
Authorized by the COC, of course. That in the representative nature, he can file. But these are technical issues, sir. These are only in the... But the problem is, sir, some of the NCLTs, we have problem where they say that you try to file an application with CD as the petitioner. You will be called by the office of the NCLT and say you change the cause title. And you change the cause title. You change the cause title, and you will get over this problem, but you lose the power or the opportunity to appeal in case you want to appeal. So now it's a catch-22 situation, whether you want to got your PUFE transactions numbered or you want to have the right to appeal in case you lose. So most RPs would say, okay, fine, I'm happy, let it get admitted here and I'm hell with it, what happens after that? Then there is one more question which I wanted to ask here is, yes, sir, suppose, assuming that we get a PUFE transaction judgment in our favor, what next? Are there any powers under which we can recover that money? If we have to recover, what is the process and how do we recover?
Well, I think that is a question which will be addressed in the afternoon session.
Okay, right. Then that's okay.
I would prefer that we wait for that. Basically, see, the thing is how to recover and all that. It all basically it becomes a part of the resolution plan also, and whether the CD and how the creditors will recover.
No, sir, I am not saying it. I am only asking at a technical aspect. I am not going it right. What the plan will say is who will be the beneficiary. What the plan will say, who will be the beneficiary?
Ultimately, beneficiary will be the financial creditors or the.
Yes, I agree. But I am saying that going on by a legal perspective, there are no provisions in the IBC which have been provided. How do we recover them?
Can I share my experience in this?
Yes, sir. Welcome.
In one of my case, I had got a favorable decision from NCLT, and the direction was given to recover the amount from the director. Yes. And when I filed the application for recovery, the director could not pay. Then the decree was issued by the NCLT. And after issue of decree, the decree was transferred to 30 Hazari Court.
Okay.
Delhi for recovery, which I have in 30 Hazari Court.
You have to file an execution petition in the appropriate civil court.
Yes, I had filed appropriate application civil court for execution of the decree. So today's status is that receiver has been appointed in my case for attachment of immovable property.
That's what, sir. This procedure is no, sir. Some of the tribunals do not issue decree. For example, in our tribunal, they ask us to file the application for contempt. In a contempt, decree cannot be issued. Now, most of the people in most of the what RPs do is non-compliant. They file contempt petition. In a contempt petition, you don't get a decree. So
Yes.
there should be a recovery. And under which provision are you going to file for recovery for decree? Under IBC, sir. Under which provision a decree can be issued by the NCLT? Under what powers?
Sir, under section 425 of the Companies Act.
So we are proceeding
Sir,
under
Rohit-
IBC and we
Sir,
are proceeding.
what has
Our matter
happened-
is under IBC, and for execution of a
Yes, our
recovery.
matter is under IBC, but IBC says that, sir, I absolutely agree with you. But when the matter came before NCLT under IBC, now in IBC, the amount has been settled, recovered amount has been agreed. Now NCLT wants to issue the decree. So at the time of issuing decree, obviously, there is no provision for issue of decree under the IBC code. Then obviously NCLT referred to the provisions of section 425 of the Companies Act, where the NCLT has power to issue decree. Accordingly, they though issued the decree under section 425 of the Companies Act, and then I went to the local civil court for execution of thereof.
Point, sir. Now the question is, the process is, for example, those who instead of we have to file two applications, one for contempt and one for recovery for decree under 425
Yes.
of Companies Act for
Yes,
recovering the
absolutely
money.
right. I had filed two applications, sir.
Yeah,
Contempt
that's good,
application,
sir.
my contempt
It's-
application was rejected.
Yes, it is enlightening. So at least we have some idea about what to do in case we have got a favorable decision. One of my colleague is
Sir, I had
facing.
filed two applications. Narayanaji, I had filed two applications, one for contempt, one for recovery.
Yeah,
Contempt
that's good, sir.
application
That should
was
be done, sir.
rejected. Contempt application was rejected, and decree was issued for recovery. And thereafter, it was transferred to the civil court for execution thereof.
Sir, in our bench, contempt is taken up, and in contempt, they are punishing issue of warrant and others.
Okay.
And I don't think anybody has filed a recovery suit in Bangalore bench so far. Maybe we should try this. We'll ask. I think we'll ask one of the
I had
one
dealt
of my
with in
colleagues.
Delhi.
No, I think that's a very valuable insight you are giving, sir.
Sir,
Concept.
you please share that number, sir. Decree that NCLT order, sir.
Definitely, sir. I will share with you because right
Share
now I
that
am
so that
fighting with
we will
NCLT
quote
Delhi.
that, and we will quote that and file here. Let us see what our people say.
Sure. Actually, in my case, and IBPI is regularly in touch with me.
Okay, sir.
Narayan sir,
Yes,
my
sir.
question is that to forum that whether NCLT has the power to execute one execution process. Can NCLT do this?
No, sir.
No, that's what I think Nazim
That's
Khan
what,
sir-
sir. They went to civil court to get the
Ah,
execution
they
done.
filed under Companies
Sir,
Act.
there is a
and
rule,
IBC.
sir. There is in NCLT rule, NCLT can make execution or any of order. Because
I
I
don't know,
have
sir.
a similar case, sir. Actually,
I
was
don't know,
fighting
sir. I
this
don't know. I don't know. I'm not aware. If there is any rule, please let me
No,
know.
no. Actually, I have also one case what the NCLT Kotak bench has rejected that application. Even I filed with the NCLT and the order was reserved and the order was in favor of me. And the Honorable NCLT has directed me to file a execution application with NCLT. And I have
Oh.
filed. There is a
Sir,
particular
under
form
section
also.
425, you can file of the
Yes,
Companies
sir.
Act.
Yes,
I am mentioning section 425 of the Companies Act.
yes,
Right, sir.
yes.
That is for decree.
So
That is
why
for
so-
decree, not for execution.
Sir,
Sir.
execution of
No,
decree.
no,
Sir,
Execution
what
decree
will happen-
already I have received, sir.
No, decree
I
is
have
given by
already received.
NCLT.
Sir, I tell you
NCLT.
what will happen. Sir, I tell you what has happened in my case. Sir, once decree is issued, you have to file an application for transfer of that decree to the civil court.
That's what, sir.
NCLT will transfer the decree to the civil court for execution thereof. NCLT has power under section 425.
Yes, sir.
Yes, sir.
I'm not denying that.
So, that's why I'm saying in case you have decree, so decree will not automatically go to the civil court.
We have to go to the civil court, sir.
It is NCLT who will refer that
Transfers.
decree to the civil court, what
Sir,
will happen?
Once already decree you have received, again who will give the decree? I have already received a
NCLT.
decree from NCLT. I have already
No,
received.
decree will be issued by NCLT. There is a prescribed
Again,
format when you will apply for issue of decree, and there is a
issue of
format.
decree or
format is
issue
there.
of execution. Execution for the filing of the execution or filing for the decree order. What we have to file on 425?
Sir, you have to file an IA.
Sir,
You have to
I
file
have
an
to
IA.
file.
Yeah,
Sir,
I have to
sir,
file
no,
an
sir,
IA.
It is
second
I think
session.
offline you
Second
people
session.
can discuss.
Yes,
Second
Raghuram sir.
section.
Raghuram sir, one question.
Yes, sir.
Raghuram sir. So to all my forums and all seniors. One
Yes, sir.
case I was handling with NCLT Cuttack bench. Okay. The
Okay.
matter was there is undervalued transaction. There is undervalued transaction related. Some of the plant and machinery was transferred to related party with a undervalue. Okay.
Okay.
So
Okay.
now what the transaction auditor has calculated the value according to your depreciation method, written down value method, 15% or 20%. Okay. He told that this machinery value as per the WDV method, machinery value stands this, suppose one amount, but it was sold for that year for a undervalue.
Okay.
So he contested that. My contention is that this is a quasi-criminal forum, quasi-criminal power of the NCLT as the quasi-criminal. This is the quasi-criminal type case. So whether the honorable court can believe on the valuation of WDV method, or the RP should have to make a valuation of a chartered engineer who can give a proper valuation of that machinery, landed machinery. But now the chartered engineer could not give because the machinery is not there.
Yes, sir. Obviously, he cannot give.
He cannot give. But the RP has assumed as per the WDV method, whether that matter will be sustainable or not. So when my contention was, it is a quasi-criminal proceeding. So I need a solid evidence, concrete evidence, where someone can punish. This is a criminal offense. So what will be your suggestion in this case?
The undervalued transaction, if you are able to, from the books of accounts and from the auditor's report, we can file for recovery. But whether it is criminal case, that is a separate matter. I don't think NCLT will get into that.
Sir, whenever I am charging the director to defer the payment of the creditors under fraudulent manner, fraudulent is 66(1) and 62(2). Is it totally quasi-criminal? So I should have to provide.
Sir, but criminal case, that's what I was mentioning, that RP has to focus on recovery part. Whether the culpability part of a particular transaction, that is to be seen separately, and some investigation has to take place separately. Maybe you can ask NCLT to engage a investigative agency to do that. You can direct for further investigation as far as criminal angle is concerned. But the main focus of CAIRP is resolution of insolvency, and
Yes,
you need to get maximization of these things only. But I don't think you will be, while focusing on criminal angle, I don't think you will be doing any part of CAIRP Act. That is not going to be the case.
We have the part of that is the 66 also, and a fraudulent to identify a fraudulent.
It is there, sir, but NCLT is not going to give directions on that.
Yes, right, sir. Thank you.
Sir, one query. Everybody was discussing about the execution of the orders passed by the Honorable NCLT in case of a PUFE transaction filed by an RP.
Yeah.
Now, as per law, what I read, and correct me if I'm wrong, it says the RP stroke the liquidator must file an application. So whether the execution part is supposed to be carried out by the RP or the liquidator, or it is just that he has to apply, and whatever happens is it happens in the normal course, and the courts take it forward from there. Because we are not supposed to act as recovery agents, right, sir? I mean, eventually, if I understand it correctly.
That is true. I think, see, this is something which NCLT has to give direction. And you say maybe when you are filing for recovery itself, you should make one of the points of prayer is that, you should tell how it is to be recovered and all that. But I don't think RP should get involved in the recovery part.
Okay.
RP has no power, sir.
So therefore, the follow-up for the execution is not material.
Basically, once it is very clear that some recovery is expected, I think these creditors will be very much interested. The secured creditors or financial creditors, they will definitely pursue it and get it recovered.
Okay.
And I don't think RP has to involve.
Okay, great, sir. Thank you.
Madam, can we close, madam? Anjali, madam.
Yes, sir.
Yeah, I think I hope the session has been useful to you. Last 3-4 days, I've taken some trouble to gather all the information and present it to you. So I'm really thankful for this opportunity, and then hope everybody has been benefited out of this.
Thank you very much, sir, for such a knowledgeable and interactive session.
Yes,
And sir, I request you please share the PPT.
Yeah, I'll share it to you, madam, surely.
I have just sent you an email, sir. Kindly revert on that.
Yes, ma'am. Yes. So I once again thank all of you for your active participation and then encouragement. And then with this, I'd like to close. Thank you.
Thank you, sir. Thank you. Thank you. Thank you for this.
Now, participants, there is lunch break till 1:30. Next session will start at 1.
I add a sprinkle of salt. Stir the onions in hot heat and start sliver from brown color along the edges. Usually it's neutral. It's used in Kashmir, but in pot.
Hear me, ma'am?
Yes, sir. Good afternoon, everyone.
Yeah.
Now, our second session will be taken by Prakul Thadi, sir. Sir is a partner at Prakul and Coover LLP Company Secretaries. He is insolvency professional.
I think we lost you, Anjali. We can't hear you. Can anyone confirm if you can hear Miss Anjali speaking?
Nobody.
Yeah. Okay, fine. I think we can start. Probably just a small introduction about me. So that's okay. I'll start off with the session, sir. So good afternoon, everyone. In today's session, I was asked to focus majorly on a role of an insolvency professional in identifying avoidance transactions and how we file such transactions and who will be in a position to file these transactions, RP or the liquidator. And in an event where we were able to identify certain transactions, but the process has been concluded in the sense that the CAIRP has been successfully resolved, a resolution plan has been approved. In such cases, what happens with this with respect to these applications? And with respect to avoidance transactions, what are the various expectations various stakeholders have from the insolvency professionals? And also certain important case laws is what I was asked to take in the session. So I thought I'll directly hit the point first by talking about one major concept of avoidance transactions, which is preferential transactions, which has got a kind of good jurisprudence, has evolved over preferential transactions in India. And even globally, preferential transactions is one such avoidance transactions, which is quite litigative because of the kind of language these transactions carry, or rather the sections carry with respect to preferential transactions. And also, apart from preferential transactions, the avoidance transactions include undervalued transactions, fraudulent trading or wrongful trading, and also extortionate credit transactions. So first and foremost, I would like to take a detailed presentation on preferential transactions along with one landmark ruling. And after this, we will look into the other type of transactions. Just a second. Yeah. Yeah. So before I run through the concept of avoidance transactions, concept of preferential transactions, let me take a minute to explain what are avoidance transactions, which are also referred to as clawback actions. Now, the term clawback gives us an image in our mind, right? So it's like an eagle clawing back something. So basically, the intention of an avoidance transaction or a clawback transaction is to go back, look back into what had happened in this company and identify certain transactions which ideally or ought not to have actually happened and claw it back, in the sense, reverse it. So avoidance transactions are always linked with reversing of such transactions. So now, how this avoidance transactions can be identified is, or rather, how do we explain an avoidance transaction is that these proceedings with respect to avoidance transactions always target to avoid a transaction which has already been entered into. So the point is, we are looking at transactions which have already happened. So we are not controlling or prohibiting any transaction, but we are trying to reverse a transaction which had already happened, and that's what is clawback, right? So to claw back the assets or property alienated due to such transaction. So where a transaction had happened and certain asset or property has been alienated, we want to claw it back into the company. That's what is an avoidance proceeding or a transaction all about. So as I was explaining, there are 5 kinds of transactions. One is preferential, undervalued, extortionate credit, fraudulent, and wrongful trading. So fraudulent transactions and wrongful trading. This fraudulent and wrongful trading have got a different jurisprudence and different understanding as per the code. But apart from that, the preferential, undervalued, and extortionate are specific sections which deal with it, which we will look into in this session. Now, fundamentally, what we need to acknowledge when it comes to an avoidance transaction is that there is a rule called pari passu rule. Now, what does this rule signify? This rule signifies that any claim against the company will always be ranked equally amongst all the claimants. So if there are 10 creditors, irrespective of their class, everything, they ideally, as per the pari passu rule, they all have to be treated equally among each other, and they'll have to be proportionately paid, right? And they are to be paid pro rata as far as the assets are insufficient. So whatever the assets are there, the assets will be distributed or realized, and the monies will be distributed only according to their share of debt. That is what the pari passu rule says. But the pari passu rule is always subject to certain preferential payments, which is provided under insolvency legislations. Now, what are these preferential payments? It's nothing but Section 53. So earlier in under Companies Act, it is 326 and 327. Under the IBC, it is Section 53. So wherever the legislation provides for a priority in payment, that will always supersede the pari passu rule. But where the legislation is silent, it is always the pari passu rule which will apply in the case of distribution of an asset among the creditors. So now avoidance transactions tend to bring back the position of the assets to justify the pari passu rule. So what it tries to say is, as a creditor, other creditors, I mean, like if there are 3 creditors, let's say only one creditor has been given the preference over the others, then it is jeopardizing the interest of the other creditors. Therefore, these assets should ideally be transferred back to the company in order to substantiate the pari passu rule. And of course, it can be distributed in accordance with Section 53. So the idea behind avoidance transactions is to ensure that the assets are not put to use only to satisfy the needs of a select creditor, and that it has to be, or it is meant to be looked into or meant to be distributed across all the creditors in accordance with a certain set of principle of distribution. That's what is this pari passu rule all about, and that's what is the idea behind this avoidance transactions. Now, it's very important for us to understand the idea behind an avoidance transaction. Only then we will have a fair understanding of what we are trying to study in these sessions. So I'm hoping that you all have got a fair idea of what an avoidance transaction is. And therefore, with this brief backdrop, we will run into the timeline provided under IBC for identifying any avoidance transaction. Now, the timeline under IBC for forming an opinion on an avoidance transaction is 75 days from the insolvency commencement date. Now, when it comes to the role of the IPs, it is this, the first immediate role with respect to avoidance transaction is to form an opinion on such avoidance transaction. Now, let's spend a minute on understanding what is meant by forming an opinion on an avoidance transaction. Now, see, fundamentally, forming an opinion has got, again, its own jurisprudence in understanding what is meant by an opinion, but not going much detailed into that, but trying to give a glimpse of what it intends is that as an insolvency professional, there has to be a justification as to why the insolvency professional thinks or opines that there is a avoidance transaction. So within 75 days, the idea is for the RP in resolution professional to form an opinion as to whether this company would have entered into any such avoidance transactions. Now, does this mean ultimately the RP has to file an avoidance application? Need not necessarily be. I would have formed my opinion basis my preliminary analysis of the books of account or the transactions or the information I've received from people. But subsequently, I might not have put any, I subsequently, when I started to determine the transaction for which the deadline is 115 days, I would have realized that it actually is not fitting within any of the sections which we have discussed before. So in such an event, then yes, we need not file an application of avoidance transactions with the NCLT. So it is not, the first and the thumb rule we need to remember is the law does not mandate you to file, irrespective of any situation, that for you to file an avoidance transaction. Only when you form an opinion, only when you realize that the transaction is fitting under these sections, you will be filing an avoidance transaction. In an event where you don't find any such transaction, you will not file such avoidance transaction with the NCLT. So that is with respect to this. Then RP forming an opinion, assuming, let's say, the RP going by the balance sheet, going by the information which he has received, and also certain earlier reports of fraud or any deviation of funds which they would have received from the banks. If the RP is of the opinion that, yeah, there may be an avoidance transaction, it is a usual practice for the RPs to appoint a transaction auditor. But is it mandatory, or is it provided in the law that a transaction auditor has to be appointed? The answer is no. It is for the RPs, like as an RP to support his services, since the RP has a power to appoint professionals. Using that power, the RP appoints an transaction auditor. Otherwise, there is no such rule provided where RP has to appoint a transaction auditor. So that is with respect to the concept of transaction audit. But this transaction audit, usually how it deals with is, it only looks back into the review period. So usually it is 2 years before the insolvency commencement date, during which time they will look into if there is any transaction which is a preferential, undervalued, or extortionate credit transaction. And of course, we'll come into what that period implies and all that. But ultimately, this is usually the scope of a transaction audit. And subsequent to this, the transaction audit, if the transaction auditor opines that there is a need to have a forensic audit done, then the same will amount to, maybe we can also have a forensic auditor in place who will have to provide a report on whether there is a fraud. So this way, an avoidance transaction will be identified during this process and it will be determined. So when we said determination of an avoidance transaction, so we determine firstly whether there is a transaction of avoidance which is entered or not. Secondly, what is the amount or quantum involved in such avoidance transaction? And the deadline for that is 115 days from the insolvency commencement date. And subsequent to this, within 15 days thereof, we'll have to file an application to adjudicating authority on avoidance transactions. So this application to adjudicating authority on avoidance transaction will be, is meant to be filed by the RP based upon what kind of determination the RP has made. And such an avoidance transaction can be either a preferential, undervalued or extortionate or a fraudulent transaction. But going by what Supreme Court had stated in the matter of JP Associates Limited and JP Infrastructure Limited, so the ruling identifies that an RP is ideally not supposed to club two different avoidance applications in the same application. So it technically means if you find a preferential transaction and an undervalued transaction both, it is preferable to file two different applications, one under section 43 and one under section 45, one for preferential transaction and one for avoidance transaction. Sorry, one for undervalued transaction. So that's ideally what the Honorable Supreme Court had kind of opined in its order. But we see different practices in this. We'll come to that as to how well can we file an application for avoidance transaction. But it is imperative that when you're filing an avoidance transaction, we need to ensure that the transaction meets the basic tenets set in the respective sections. So with a preferential transaction, it has to meet the basic tenets which is prescribed under section 43, which we will look into. And then we'll have one more, which is within 7 days of filing of an avoidance application. We have a form called CAIIB 6, which is filed after filing of an avoidance application, which is filed within 6 days thereof. And within 140 days from the insolvency commencement date, we need to file another form, which is CAIIB 8, which is filed with the IBBI. And this is filed within 140th day as to whether did you form an opinion? Yes, no. If no, why? If yes, then what? Then whether did you determine a transaction? If yes, good. What was the transaction? If not, why didn't you determine a transaction? And then if you filed a transaction with the whether you have filed an avoidance application or not. If you filed, what was the avoidance application? If not, why didn't you file the avoidance application? So this way, CAIIB 8 is also dealt with. So this is the overall picture of avoidance transactions prescribed under the code. So now let us look into the concept of preferential transactions as prescribed under section 43. So section 43 of the code provides for certain basic criteria based on which a preferential transaction has to be looked into. So first and foremost, it says that there has to be a transfer of property or interest thereof. So on the extreme left of the slide, you can see that first ingredient which is required is with respect to transfer of property or interest thereof. Now, when we go back and look into the definitions of property and transfer under the code, okay, so the IBC itself defines both these terminology. So first and foremost is transfer. So the IBC under section 3, subsection 34, it states that transfer includes sale, purchase, exchange, mortgage, pledge, gift, loan, or any other form of transfer of right, title, possession, or lien. So what it tries to say is that a transfer need not necessarily be an alienation of a property with respect to a sale. So we should not be of the impression that only when there is a sale of property, preferential transaction will come into picture. The answer is no. Even if the property is gifted, or even if the property has been mortgaged, that an encumbrance has been created, or a charge has been created, all of that will come within the concept of transfer. And even if it is leased, that also will come within the aspect of transfer. And then it also talks about property. Now, what means property? Or what does property mean? So it says property includes money. So it need not necessarily be that as an asset is transferred. Even if a payment is made, that also will come within the ambit of transfer of property. Goods. So where you're supplying goods, that also will come under the aspect of transfer of property. Or actionable claims, any claims which have been assigned, land, or every description of property And such a property need not necessarily be in India. It can be situated in India or outside India. And every description of interest, including present or future or vested or contingent interest arising out of or incidental to the property. Okay. So, or incidental to. So fundamentally, property again is a wide term, or has a wide purview with respect to its implications. And therefore, transfer of property should not just be visualized to be a simple sale of an asset. So transfer of property includes a lot of scope when we read these two definitions. So the reason why I was referring to the definitions is that there will be situations where we refer to certain avoidance transactions. We find out and trace out certain avoidance transactions, but we will think preliminarily that, okay, this may not fit under a preferential because it's just a lease of the property, or there's a license only, it's not a sale. So that way it should not so occur that a transaction is not given its implication. If a transaction is fitting within the definition of this transfer of property, then you should run through the rest of the section to see if it is fitting within the definition of preferential transaction. That is of paramount importance when we are identifying a preferential transaction. Next step is that such a transfer of property or interest is for the benefit of a creditor, surety, or a guarantor. Now, it is for the benefit of a creditor. If you observe the section does not say that the transfer is to a creditor or to a surety or to a guarantor. It says the transfer is for the benefit of a creditor or benefit of a surety or benefit of a guarantor. Now, what does benefit mean? The law is silent. The law doesn't say that benefit shall necessarily mean a monetary benefit. So which means it can be a monetary or a non-monetary benefit. It can be a tangible or an intangible benefit, right? So ultimately, as an RP, if you can prove that there is a benefit, then yes, it is a strong case, or it is a fit case for you to fight for an avoidance transaction. So it has to be for the benefit of a creditor, surety, or guarantor. Now, when we say benefit of a creditor, what does it imply? Firstly, if you're transferring it directly to the creditor, yes, of course, it comes within this ambit. But if it is transferred for the benefit of, so how do we prove there is a benefit? So in the landmark ruling of Supreme Court in JP Infrastructure and JP Associates case matter, it was held that the benefit, if there was a creditor, so the holding company has already been an operational creditor on the books of the corporate debtor, and the corporate debtor had given mortgage to the loans or the creditors of the holding company. So the holding company creditors have given loans to the holding company purely based on the mortgage of asset, which is nothing but transfer of property by the corporate debtor. So it is benefiting the operational creditor, which is the holding company in this case, by virtue of receiving that additional loan from its lenders. So therefore, they held this transaction to be within the four walls of Section 43. So there has been a transfer of property and it has benefited the creditor. So that's where we could come with the basic idea of a preferential transaction. So the second step is that transfer shall be for the benefit of a creditor, surety, or guarantor. And then it has to be on account of an antecedent financial debt or operational debt or other liabilities. So that means there has to be a pre-existing debtor-creditor relationship. So now it doesn't just end for the benefit of a creditor, but such a benefit has been given on account of an antecedent debt. So which means by virtue of this transaction or by virtue of this transfer, so-and-so person should not become a creditor. In such a case, it's not a preferential transaction. That a creditor, there is an already existing creditor, and by virtue of this transaction, that respective creditor has got a benefit. So it has to be a pre-existing debtor-creditor relationship, and there has to be, or this transfer for the benefit of a creditor has to be on account of an antecedent debt. And such debt can be a financial debt or an operational debt. Which means the creditor who has been benefited may or may not be an operational creditor or a financial creditor. But sorry, may be a financial creditor or an operational creditor, but that fellow has to be a creditor even before this transfer had taken place. So that is point number 3. And point number 4, by virtue of this transfer, such a creditor, surety or guarantor has been put in a beneficial position than it would have been under section 53. Now, what does this say? It says that, so the waterfall which is provided under 53, had this transfer had not occurred, so had this transfer not occurred, had there been no such transfer of a property under section 43 or whatever, if had there been no such transfer, if at all the creditor is continuing as it is without any such transfer, he would have received some X rupees under section 53. But by virtue of this transfer, suppose the creditor had already recovered an amount which is in excess of this X. So this means there is a beneficial position than it would have been under section 53. That is number one. Second example, let's say it is an unsecured creditor. Now, right before the company is entering into insolvency, you created a security interest to this unsecured creditor, and thereby virtue of which this unsecured creditor had become a secured creditor. Okay. In such a situation, such a secured creditor, so by virtue of this, such a secured creditor will come top in the ladder under section 53, right? But had this transfer not taken place, such a creditor is to be considered as an unsecured creditor, and they will come much below in the table under section 53. So this means that where an unsecured creditor has been transferred, or a mortgage has been created in favor of an unsecured creditor to make him a secured creditor, that such a secured creditor, or such a creditor is deemed to be put in a beneficial position than it would have been under section 53. Because had this transfer not taken place, the position under section 53 is much lower the ladder. Because this transfer mortgage has been taken in favor of the creditor has now come in the top of the ladder under section 53. So there is certainly a beneficial position than it would have been under section 53 of the code. Yeah, so there is certainly a beneficial position than it would have been under section 53 of the code. So this is with respect to the major ingredients of considering a transaction to be a preferential transaction. So as I was referring to this landmark ruling of the Supreme Court, so in that case, Supreme Court had given a layout as to what an RP has to do. So there the Supreme Court says that firstly, the RP has to go look back for the 2 years preceding the insolvency commencement date, look at each and every transaction and come to a conclusion whether the transaction is a preferential transaction or not. For that, you need to lay down all these 4 criteria and see whether there was a transfer of property. Yes. Whether it is for the benefit of a creditor, surety, or a guarantor. Yes. Is it with respect to an antecedent debt? Yes. And is it putting such creditor in a beneficial position than it would have been under section 53? And if the answer is yes to this also, then it is a preferential transaction unless it is meeting the exceptions provided, which are marked in red. And the exceptions are 1, ordinary course of business of financial affairs of the CD and the transferee, and 2, the new value exception. So these 2 exceptions we'll look into. But before that, one important thing we need to understand is with respect to the look back period or the period of review. So this look back period or the period of review will be different for different categories. If the creditor, surety, or guarantor for whom the benefit has been provided is a related party, then the look back period shall be for 2 years. And if it is for others, then that is non-related parties, the look back period will be for 1 year. So this only during these, this is again, it's very important to understand that the NCLT does not have any discretion to extend this look back period because it is laid down in the law. So the NCLT has to stick to this avoidance transaction timeline. And if a transfer had occurred even a day before such a timeline, it will not come within the ambit of 43 to 50. It may come as a fraudulent transaction, but definitely not as a preferential transaction. So the look back period is absolutely important because the law does not want to provide for any discretionary power to anybody. The law wants to provide a deemed fiction. If these 4 things or 4 criteria are met, the transaction shall be a preferential transaction is what the law states. And if it is a preferential transaction, then unless it has an exception of these 2, that is ordinary course of business and new value, there is absolutely nothing which can save the transaction from being a preferential transaction. Even the intent, even if such a transfer had occurred with a good intent, it will still not be considered as a preferential transaction. So this is what is 43. If there are any questions so far, I would like to take it up. If not, I'll continue with the exceptions. Okay. So I'll proceed. I'm assuming that there are no questions. So going to the exceptions. Yeah. So the first exception is with respect to the ordinary course of business or financial affairs. Now, with respect to the first exception, so what it tries to say is that where a transaction or where this transfer of property had happened to a creditor or for the benefit of a creditor, surety or guarantor, and if it is in the ordinary course of business or financial affairs of the corporate debtor and the transferee, in such a case, it shall be considered as an exception and it will not be treated as a preferential transaction. So there is something interesting to understand here. Even today, if you read this section 43, the language used will be ordinary course of business or financial affairs of the corporate debtor or transferee. But the Supreme Court had read this term or as and. The reason being that an ordinary course of business shall be between these two parties. An ordinary course of business of one party cannot necessarily give the nature of an ordinary course of business for this transaction, right? So technically, you will have to prove that it is an ordinary course of business of the corporate debtor and such transferee. Only then you can come to a conclusion that it is not a preferential transaction. Now, proving it to be within or proving it to be an ordinary course of business or financial affairs is a difficult task. The reason why it is a difficult task is that you need to understand that, I mean, see, one thing is having a series of transactions. Now, if at all a transaction has occurred multiple times, does that mean it's an ordinary course of business? It need not necessarily be. Because in the Supreme Court order in the JP Infra and JP Associates Limited matter, that was what was the situation. The banks were taking this third-party mortgages for quite some time and they were being renewed from time to time. But as per the Supreme Court, just because it has been routinely done or it has been done multiple times doesn't necessarily mean it is an ordinary course of business or financial affairs. So the transaction or the transfer has to occur in a way that it is meant to be in the business of both the entities, right? A frequency of the transaction does not decide it to be whether it is in the ordinary course of business or not. That's what is the conclusion we can draw. So ideally, it's like an open-ended, it's like an open-ended, of course, an open-ended interpretation. And there is a huge scope for advocates and RPs to play with the language here and also try to justify how a transaction can be considered as cannot be considered as an ordinary course. And similarly for the transferee and the other party who is being put at the situation of reversing the transaction, they can also, or against whom the avoidance transaction has been passed, they also usually take the shelter of ordinary course of business or financial affairs. So this ordinary course of business exception is widely applicable across all the transactions. And usually that will be one strong defense coming from any party against whom an avoidance transaction has been filed. Right? So now let's move to the other exception, which is a new value exception. This new value exception is quite interesting and confusing at the same time. So when we read the definition of a new value exception, we may actually have some kind of a difficulty in understanding the intent behind the transaction. And therefore, I tried to break it down in a way that it has a clear meaning. And of course, in the subsequent slide, I have a detailed presentation on it. But what necessarily this new value exception says is that if the transfer of property has been done And it is done only for the purpose of creating a security interest in the property which is acquired by the company. So a company, let's say, has acquired 2 acres of land, and the same land has been secured in favor of a creditor. Now, this is a transaction which this new value is talking about. In such a case, such a security interest in the property should be to secure the new value. And the new value is given at the time of or after entering into security agreement, and new value is used by the company to acquire the property. So which essentially means there is a creditor who has given me money, and that money I used to acquire a property, and the same property I'm creating a security interest in favor of the creditor who has given me the money. This transaction will come within the ambit of a new value transaction, and it will be exempted. The reason is because the money has been received and the money has been utilized toward acquiring a property, and the same property is secured in favor of this existing creditor, though it is an antecedent debt, though it is for the benefit of the creditor, though the creditor was earlier an unsecured because of the money given at the time of acquisition. But ultimately, that money was used for acquiring the asset, and the same asset has been secured in favor of the creditor, and therefore it will not come within the ambit of preferential transaction. That's what is the law on with respect to new value exception. So we will first let us try to understand what is a new value exception in great detail. Okay. Yeah. So new value exception, as I said, I mean, basically how the new value is defined is that it is either money or it's worth in goods services. So as I said, there has to be new credit given or a money which is brought into the company, or where there is a release by the transferee of property previously transferred to such transferee in a transaction that is neither void nor voidable, including proceeds of such property. Now, this release part is a bit tricky, so I wanted to explain it by way of a pictorial representation. So what is essentially happening is there is a transferee of a property which was previously transferred to such transferee, right? That release of the property will also be considered as a new value. How is it? Is what I am explaining in this on this slide. So let's say there is the company is PK Limited and the creditor is VKBI. So where the company, the CD had transferred or created a mortgage transaction or security interest in favor of this creditor, and this is very clear, it's a non-voidable transaction, or it's neither void nor voidable in the opinion of the RP or the liquidator. And subsequent transaction is where the creditor has released the property in favor of the company. Now, why this release of the property is considered as a new value? Because the same property which is released will be utilized either by way of sale or anything for acquiring another new property, and such new property will be secured again in favor of this creditor, which is VKBI. So ultimately what happened is VKBI earlier, the creditor had earlier another security interest that has been released, and the released property has been sold, money has been recovered, and that money has been utilized for buying another property, and that new property is again secured to the original creditor. Now this also will come within the ambit of new value exception, right? So see, these are some far-fetched illustrations which I can understand, but this is exactly what this definition of new value implies, right? So this is all with respect to avoidance, preferential transaction under section 43. So before I conclude, let us just spend a couple of more minutes on understanding few important provisions under section 43. One is with respect to transfer which is made in pursuant to an order of the court. Now, generally, our opinion will be that wherever there is a specific order pursuant to which, let's say, an asset has been transferred, then we will be of the impression that it will not come within the ambit of preferential transaction. But what the section 43 clarifies is that even if a transfer has been made by virtue of an order, it will not preclude it from being considered as a preferential transaction. So as long as the transaction meets these criteria, it will be a deemed preferential transaction, irrespective of whether such a transfer had occurred by virtue of an order of the NCLT or order any forum. So even if the parties have transferred the assets by virtue of an order of any forum, as long as it is meeting the definitions of avoidance transaction, the transaction shall be deemed to be a preferential transaction. That this is one very powerful provision under section 43. And to my knowledge, I haven't seen any orders under the IBC, particularly relying on this particular provision. And next, with respect to forming of an opinion, as I said, I was just trying to understand on the opinion front. So in one judgment of Supreme Court in Rohtas Industries versus SD Agarwal, it clarifies that an opinion. So here, of course, it is not talking about opinion of an RP because it's a 1969 judgment. But technically, what is an opinion is something which is being dealt with in this, wherein it says an opinion must be a real exercise of the discretion. The authority must be exercised honestly and not for corrupt or ulterior purposes. And it must form the requisite opinion honestly and after applying its mind to the relevant materials before it. So, forming an opinion should not be vague or absurd. It has to be based on certain relevant substantiated material. And with respect to ordinary course of business, the Supreme Court, when it was dealing with the JP case, it was actually considering these two judgments. One of High Court of Andhra Pradesh in the matter of State of Andhra Pradesh versus H. Abdul Bakshi and brothers in 1964, where it held that an activity could be regarded as business if there is a course of dealings which are either actually continued or contemplated to be continued with a profit motive. So business is always linked with a profit motive. So just merely a course of dealing, that is a multiplicity of a transaction or frequency of a transaction, does not necessarily mean it's business. Business has to be with a profit motive and it has to be in a continued fashion. And in the case of Downs Distributing Company, wherein the order was passed by High Court of Australia, wherein it says that an ordinary course of business means that the transaction must fall into place as part of the undistinguished common flow of business done. Now, a company is into certain business. Now, this has to come within the undistinguished part of that particular business. And that it should form part of the ordinary course of business as carried on, calling for no remark and arising out of no special or particular situation. So, it has to be a business with a profit motive carried on and not to be distinguished from the common flow of business which it does. And there should not be a special need or a situation for the transaction to have occurred. In this JP infrastructure matter, as I was telling you, there was a third-party mortgage which was created for raising of loan. So as far as this company is concerned, that is a subsidiary which has given the security interest in favor of the lenders of the holding. As far as this transfer is concerned, if you see, it is arising out of a special situation because the holding company needed additional security interest. Only because of that the subsidiary company had given it, that transaction. But looking at the subsidiary company, is there any business motive for the subsidiary company to give the security interest in favor of the lenders of the holding company? Is what is the question asked by the Honorable Supreme Court. And of course, the answer has come in the negative and therefore it is held as a preferential transaction. So, ordinary course of business is quite tricky, and understanding of it and explanation of it before the tribunal also becomes quite an important task. So this is all about section 43 and the concept of preferential transaction. So with this, let me run you through one case study as I was discussing, which is, I'll quickly update the case study, which is of JIL-JAL, that is JP Infrastructure and JP Associates Limited. So this is a pictorial representation of what exactly is the transaction, right? So JP Associates, JAL, and JP Infrastructure, JIL. So these are the companies. JIL, JAL is the corporate debtor. JAL is the holding company of the corporate debtor. And there are lenders of the holding company. Now, the corporate debtor had mortgaged its assets in favor of the lenders of the holding company. And by virtue of this mortgage, the lenders of the holding company have have provided loan to the holding company, right? Now, this holding company technically has utilized the properties of the subsidiary to avail its loan. That is what is the transaction which had happened. That's all. Now over here, the subsidiary which is GIL is undergoing CAIRP, and the RP of this company claims that this transfer of property by virtue of creating a mortgage in favor of a lender of holding company has benefited the holding company, and therefore this transfer or the mortgage created by the company in favor of the lenders of the holding company shall be treated as a preferential transaction. That was the allegation. So now it went till the Supreme Court stage, and where the Supreme Court had been dealing with this particular transaction, it has analyzed in this fashion. First and foremost, the question before Supreme Court was, what was the relevant period? Was this transfer, when did this transfer happen? Is it before 2 years or 1 year? Is it within the relevant period? Now, there's an interesting element to discuss here. So the stand of JP Associates Limited was that this transfer had happened to an unrelated party, which are the lenders of the company. Since the transfer had happened to the lenders of the company, it is an unrelated party, and therefore the look back period shall be 1 year. And since this transfer had happened before the 1 year period, and hence it will not come within the ambit of section 43. That's the argument of JL. Now coming to the argument of the RP of GIL, that is RP of the subsidiary, the RP states, or the RP's counsel states, that though the transfer is to the lenders who are unrelated parties, but it is for the benefit of the creditor, which is the holding company, by virtue of it being an operational creditor. So they say that the transfer is by virtue of this. I mean, the transfer had happened for benefiting this creditor, and it is not just for benefiting the secured lenders. Since it is for benefiting the creditor, which is a related party, the look back period shall be 2 years is what is the argument, and it has been successfully run through to the Supreme Court, and Supreme Court was convinced with that argument and considered that yes, this transaction had happened for the benefit of a related party, and therefore it is held within the past 2 years. Next question is whether this transaction is excluded with respect to an ordinary course of business or a new value. And the answer to that is no. There have been, of course, arguments stating that this transaction has been entered multiple times, but the Supreme Court was not convinced of the multiplicity or the frequency of the transaction, and therefore held that transaction to be not within the ordinary course of business. And of course, new value does not apply. Next comes the major 4 criteria as to whether there is a transfer of property or interest thereof. Yes, because the assets of the corporate debtor have been mortgaged, which is nothing but a transfer. So the answer is yes. Next, is it for the benefit of the creditor or guarantor or surety? Yes, it is benefiting the existing creditor, which is the holding company, right? Which is, of course, an operational creditor as well. Then, has the transfer happened for or on account of antecedent debt? Yes, there is a pre-existing debt, since JP Associates JL is also an operational creditor of the company. And finally, is this put in a beneficial position to JAL, the holding company, than it would have been under section 53? Again, the answer is yes from the Supreme Court, in the sense that had this transaction not occurred under section 53, had this transfer of property not happened, then the holding company would have just been an operational creditor without any other benefit. Because of this additional mortgage being given, the holding company was able to raise debt, and therefore it had kept itself in a better position than it would have been under section 53. Therefore, it is to be treated as a preferential transaction. So since all the ingredients have been met and the exclusion has not been made applicable, therefore the Supreme Court held that this transaction shall be deemed to be a preferential transaction without there being any need to understand the intent of the parties. And therefore, the Supreme Court held this transaction as a preferential transaction. So in the ambit of preferential transactions under section 43, this order of the Honorable Supreme Court in JP Associates versus JP Infra in this case of JP Associates and JP Infra, stands out to be one of, or rather the most important and the landmark rulings under avoidance transactions in India till date, I would say. So this is all about a preferential transaction, and preferential transaction needs such thorough deliberation. So with this backdrop, if anyone has any questions on preferential transactions, you're most welcome. If not, I will carry on with the next set of transactions, which is undervalued transactions. Okay, fine. So I'm assuming that there are no questions on preferential transactions. Coming to the undervalued transaction. So as per section 45 subsection 2, a transaction shall be considered as an undervalued transaction where the corporate debtor makes a gift to a person. So giving a gift to a person is deemed to be an undervalued transaction without applicability of anything, of course, subject to exception of ordinary course. Okay, so a gift is deemed to be an undervalued transaction unless it is in the ordinary course of business of the company. Second, or enters into a transaction with a person which involves the transfer of one or more assets by the corporate debtor, okay, for a consideration, the value of which is significantly less than the value of consideration provided by the corporate debtor. So it means that if you have put some value for acquiring an asset versus at what value are you transferring the property to someone, the difference should not be significantly higher. So if the transaction or the subsequent transfer is done at a lesser value and it is significantly less than the consideration which has been kept for acquiring such property, then in such a case, it will be considered as a undervalued transaction. But what is meant by significantly less is something which is not defined. And for that, if the NCLT has the power to even appoint a independent expert who can opine or assess whether the transaction in with respect to assessing the value of that particular transaction or value of the consideration of that particular property. And the exception for section 45 is that such a transaction has not taken place in the ordinary course of business of the corporate debtor. So this is with respect to an avoidance transaction. And the relevant period for avoidance transaction remains the same as is for preferential transaction. It is 1 year for related parties, so non-related parties, and 2 years for related parties. Okay. So that is with respect to avoidance transactions. And next is with respect to, undervalued transactions. And next is with respect to extortionate credit transactions. Section 50. Now, what does extortionate credit transaction do? What does it state? It says that where a CD has been party to an extortionate credit transaction and the relevant period is only 2 years, irrespective of whether it is a related party or an unrelated party or non-related party, it is only for 2 years. So where a CD has been a party to an extortionate credit transaction within the 2 years period, then this has to be, the RP has to make an application with the NC and the adjudicating authority. Now, what are extortionate credit transactions has been dealt with in the CAIIB regulations. So we will just have a quick glance through as to what are the extortionate credit transactions. So regulation 5 of the CAIIB regulations, that is IBBI Insolvency Resolution Process for Corporate Persons Regulations 2016. So this regulation 5 states that a transaction shall be considered extortionate under section 50 subsection 2, where the terms require the corporate debtor to make exorbitant payments in respect of the credit provided or are unconscionable under the principles of law relating to contracts. Now, see, the idea is that it has to be so high that it is not as per the market standards, it is unconscionable, and also that there are exorbitant payments sought with respect to whatever the loan has been asked for. So this is again should have been occurred 2 years before the insolvency commencement date. So this is a third set of avoidance transaction, which is extortionate credit transactions. So The other two, with respect to fraudulent and wrongful trading, are dealt with in a different chapter under section 66. So 66(1) deals with fraudulent trading and 66(2) deals with wrongful trading. So what is a fraudulent trading? It states that during this process, whenever it is found that the business has been carried out with the intention to defraud the creditors, in such a situation, the NCLT may, on the application of the RP, pass an order that any persons who are knowingly parties to the carrying on of such business in such manner shall be liable to make contributions to the assets of the CD as it may deem fit. So what it essentially tries to say is that where the business was done fraudulently or for a fraudulent purpose to defraud the creditors. So the intention is very important. Under section 43, 45 and 50, one thing you should have observed is that there is no question of intent. There is a deemed fiction. Even if your intentions were good, it will still be considered as an avoidance transaction. Whereas under section 66, there is a dire need to establish that there is an intent to defraud. Now, who has the onus to prove that there is a fraud or there is not a fraud? Now, this is a very important question to answer. The NCLTs, in some cases, look at the petitioner to justify as to why there is a fraud from the aspect of the creditor. So it is ideal that the RP has to have the onus to prove whether a transaction, why that RP thinks that a transaction is fraudulent. But similarly, of course, there is a defense available to the promoter or whosoever be the director or whosoever be the person who is carrying on the activity of this company in a fraudulent manner. They should be given an opportunity to justify as to why there is no fraud. So fraud is actually a very difficult thing to prove, and therefore it needs a good, I would say, good amount of time spent on understanding how it is a fraud. That is with respect to fraudulent trading. Coming to wrongful trading is an interesting aspect under section subsection 2, 66 subsection 2. What it says is that before the insolvency commencement date, so at any time, before the commencement date, where there's a director or partner as the company, they ought to have known that there was no reasonable prospect of avoiding the commencement of CAIRP. So which means where the person in charge, the director or partner, they ought to have known, based on their qualification and all that, they ought to have known that, okay, this company is failing, right? And I have no other option. This company will end up in CAIRP. In such a situation, and such director or partner did not exercise due diligence in minimizing the potential loss to the creditors of the CD. So even after knowing that this company might end up in CAIRP, even after that, if they have done some kind of a trading in the company, which is much further jeopardizing the interest of the existing creditors, then it will be considered as a wrongful trading, right? And with respect to this wrongful trading and with respect to the diligence, what it says is that if the director or the partner, as the case may be, will be deemed to have exercised their diligence, if such diligence was reasonably expected of a person carrying out the same functions as are carried out by such director or partner in relation to the corporate debtor. So the idea is to look at a reasonable expectation, not just comparing them with some topper of the industry or something, where such a director having such a qualification is something which will be looked into. So reasonably what was expected from them is something which will be identified. And if such a reasonable expectation is not being met, then it will be considered as a wrongful trading. So these are the 5 different avoidance transactions as identified by the IBC, or as identified in the IBC by the, as identified in the IBC, right? So any questions so far from anyone? Okay. Now moving back to our topic. So be it a preferential or undervalued or extortionate or fraudulent or wrongful trading, whose responsibility is it to file such an application before the NCLT? The responsibility ultimately will be of the resolution professional and is not of the COC. That's for sure. But is there a provision where the creditor can file an application? Certainly, yes. It is only in the situation of section 49 where the transaction has been entered to defraud, where an undervalued transaction has been entered to defraud a creditor, then the creditor will have a right to file an application before the Honorable NCLT. So it is only in respect of on section 47, sorry, not 49, 47. So where it is an undervalued transaction, but the RP or the liquidator have not reported it, in such a case, only the creditor will have a right to file an application, particularly only in case of undervalued transactions. Okay, fine. So this is with respect to this. Yeah. Now coming to the role of an auditor. Now, what is important, as I was explaining you this, the concept of this transaction auditor or the forensic auditor definitely was there even before IBC has come, but the scope of them is certainly limited. In the sense that firstly, there is no regulatory body which guides what they do, how they do, and which kind of gives a indication of or authentication of what they certify. So, like for example, a statutory auditor, a chartered accountant, certifying a transaction, certifying an audit and saying that there are no qualifications and all of the books are audited and they are in compliance of the accounting standards is there authentication that yes, it is it is an authentication that the financial statements are final. But when it comes to avoidance transactions, the report of a transaction auditor is only to support the view of the RP. There can definitely be a situation where the transaction auditor report says something. If the RP is of the opinion that it is wrong, and if the RP strongly believes that there is a scope for filing an avoidance transaction, nothing stops the RP from filing the avoidance transaction. So a transaction audit report is only to help the RP in forming an opinion. It is not meant to decide, or it is not meant to finally determine whether a transaction is avoidance or not. It is only the RP's decision making which will decide if a transaction is an avoidance transaction or not. So all these transaction audit reports will be subject to review by the RP, and RP has every right to deviate from what is given in the transaction audit report, as long as the RP can justify its stand. But the fact is, this transaction audit report need not necessarily be filed with any authority, need not be disclosed to NCLT or whatever. So technically, it is the RP who has formed an opinion, will file an application under the relevant section, if the RP is convinced that there is an avoidance transaction. So the question on role of our auditor with respect to an avoidance transaction will not actually be will be only limited to assisting the insolvency professional, assisting the RP to form an opinion, assisting the RP to determine the transaction, or assisting the RP or in filing of the avoidance transaction. That's all. It is only subservient to the role of the RP. It will not be in supersession of the role of the RP. Now, coming to filing of an application for avoidance under section and under the IBC. So as we have seen, there are different sections for avoidance transactions. If the RP was able to identify certain transactions under 43, then RP need not wait for the exercise of 45. RP can immediately file an application under 43. It is always advisable to file different applications for different sections. So under section 43, it is advisable to file one single application. There may be multiple preferential transactions, but it is ideally it is better to file all that under one application under section 43. Or if suppose certain transactions have not yet been identified or in the process and it is taking time, then if a transaction has already been identified, then the RP can continue filing an application for that one particular transaction alone under section 43. So when we are filing the transaction, particularly under 43, so we have seen that there are certain ingredients like these, correct? So the application should ideally, in a tabular format, identify as to how your transaction meets these minimum ingredients under section 43. Like suppose 43 needs that there is a transfer of property or interest thereof. Then on the right, in the tabular format, on the left, it says transfer of property or interest thereof. On the right, we need to justify how in your transaction there is such a transfer of property. Second, with respect to benefiting a creditor, surety, or guarantor, then you need to justify as to how it benefits a creditor, surety, or a guarantor. Third, an antecedent debt, whether it's an antecedent debt, then you need to prove how it is an antecedent debt. So this way, a tabular format is important in order for the NCLT to immediately have a quick grasp of what this transaction is about, what this application is about, and that it meets the minimum ingredients. That is with respect to section 43. Similarly, for 45 or 50, explaining the transaction is of really good importance. So as resolution professionals, we need to simplify the transaction as much as possible. When I say simplify the transaction, my intention is to simplify the understanding of the transaction for the NCLT. See, though the NCLTs are meant to be that having this financial acumen, but it is not always the case, because usually the legal acumen will dominate the financial acumen when it comes to NCLTs in India. So it is always important for us to explain the transaction in a great detail, to simplify the transaction so that the NCLT member, the technical or the judicial member, will immediately understand as to what had taken place, and even the annexures should try to highlight as to what is a important aspect which can explain the transaction in a quick manner to the NCLT. So explaining the transaction has to be very important and extremely careful while drafting the transaction per se. Second is with respect to justifying the transaction as to how it is an avoidance transaction. How is it an undervalued transaction? How is it an extortionate credit transaction? So over here, as I was explaining, we should try to highlight what is the legal provision and how does this transaction meet this particular legal provision. And then most important is the prayer clause. What are you praying from the NCLT? Like, for example, there is a security interest created under section 43, which is a preferential transaction. So what is your prayer? Is your prayer to release that property back to the company? Then you will have to very clearly write release of property under section 43. But before you can draft your prayer clause, it's always important for you to read the relevant sections wherein the NCLT has been given the power to pass certain reliefs under the avoidance transactions. See, under 43, preferential transactions are provided for, and section 44 provides for what are the orders an NCLT can pass, the adjudicating authority can pass in the case of preferential transactions. So under section 43, there are certain things which are laid out. One, it says, I'm not going to run through all of these, but yeah, as you can see that whenever you're drafting an avoidance application, if it is a preferential transaction, one should refer to section 44 to understand what are the orders which can be passed in case of preferential transactions. And you need to draft your prayer clause in a way that it is falling under section 43, so section 44(1). Okay, only then the NCL, the adjudicating authority, will have the power to pass a particular order. So your drafting of the relief clause or the prayer clause is also of utmost importance. So first, explaining the transaction. Second, giving a correlation between the transaction and the legal provision to justify that the transaction is meeting the four walls of the avoidance transaction, be it a preferential, undervalued, extortionate, fraudulent, or wrongful trading. And third, drafting of the prayer clause. What are you seeking from the NCLT is also of paramount importance whenever you're drafting an avoidance application. Similarly, for undervalued transaction, we have section 46. We have section 48, which talks about the orders which the NCLT can, which the adjudicating authority can pass with respect to undervalued transactions. Then we have for extortionate credit transactions, what orders can be passed in respect of extortionate credit transactions is provided under section 51, right? And for section 66, we have section 69. Sorry, 67. Section 67 provides for what reliefs can be passed by the NCLT with respect to transactions provided under section 66. So 67 provides that these are the various reliefs which can be sought. and what power the NCLT has, what directions the adjudicating authority can pass is provided under section 67. So it is very important for the one who is drafting an avoidance application to specifically refer to these sections with respect to whatever be the avoidance transaction. The relevant section shall be looked into to see whether the prayer you are seeking from the NCLT is falling within these four walls or not. Because one has to understand that even adjudicating authority has limited role under IBC and only a role which is prescribed. So wherever it is not prescribed, it has become a practice to go through the inherent powers of the NCLT. But otherwise, when it comes to a specific subject matter, the specific section shall provide that power. And anything beyond that cannot be implied by the NCLT, particularly when it is clearly specified. Probably if it is absent, then maybe you can rely upon the inherent powers. But where things are specified, it is not right on the part of the, it's not right on the part of the professional to seek additional powers. Is not right on the part of the NCLT to also avail on the inherent powers. So these sections, which are section 44, section 48, section 51, and section 67, provide for the scope of the adjudicating authority in terms of passing its directions under preferential, undervalued, extortionate credit, fraudulent, and wrongful trading transactions. So this is with respect to how is it that an application will be filed. And of course, in order to file this application, it's a similar application like any other application. The IA will be filed through e-filing mode by the RP, and it will be defended by the RP. And so it's a next, and after this three things which I was explaining, another important thing when you are drafting an avoidance application is with respect to joinder of parties. So whom all will you make the parties to the transaction or to the application is also of pretty good importance. And such an application will be filed through the e-filing portal. And with respect to what are the NCLT, what are the provisions in respect to NCLT, that will be looked into and filed. Then, who can find these transactions and file it before the adjudicating authority? Is the RP or the liquidator. Now, if you see section 66, it says if during the CAIRP or a liquidation process, right? Then similarly, if you see the other provisions, if you see section 43 on your screen, it says where the liquidator or the RP. Similarly, 45, if the liquidator or the RP on an examination of the transactions. Similarly, 50, where the CD has been so and so, the liquidator or the RP, right? And even in 66, I've shown you that. So the idea behind this is that the applications under 43, 45, 50, 47, and 66 need not necessarily be filed by the RP. Such an application may also be moved by the liquidator. Now, just imagine a situation where in the first COC itself, the COC had decided to go for liquidation. Then it definitely becomes difficult for the RP to conclude on the avoidance transaction, because usually the COCs will not approve any budgets once the liquidation is approved by the COC. Right? So in such a situation, it becomes imperative that the liquidator will look into it and not the RP. Now, second, if the let's take a situation where the RP had done a transaction audit, but RP could not conclude on a transaction, and therefore, because of, let's say, for lack of information, RP could not conclude on the determination of avoidance transaction. But that information was received during the liquidation process. Then yes, liquidator is within the powers to continue the avoidance transaction. And the RP and liquidator need not be the same person. Let's say the RP is a different person, but as per that RP, their transactions are not avoidance. But a different liquidator has been appointed, and the liquidator is of the opinion that no, these are avoidance transactions. Can the liquidator file such an application? Yes, the liquidator can definitely file such an application before the NCLT. But there are situations like, for example, the RP had already preferred the transactions as avoidance before the NCLT. And let's say the RP is substituted by a new liquidator. The liquidator can very well continue litigating such transactions, such applications. Similarly, the liquidator can also initiate a new transaction which was not earlier filed by the resolution professional. So this way, both the RP and the liquidator have been given the authority to file for avoidance transactions before the adjudicating authority. Now, with respect to applications pending before the NCLT, before the adjudicating authority, even after the application, the CAIRP has been approved. Now, this is one interesting provision and which needs a deliberation of section 26. Now, section 26 of the code says application for avoidance transactions not to affect proceedings. Yeah, sorry. So whether so what section 26 essentially says is that where an application was filed under avoidance transactions, such an application shall not affect the proceedings of the CAIIB. So section 26 is very clear. Your avoidance transactions can continue even after the resolution plan is approved. That's what is section 26 all about. Now, with respect to with respect to this avoidance transactions not affecting the proceedings of the CAIIB, what does it say is that where an application has been, particularly when a resolution plan has been approved, it so happens that the new resolution applicant will have to think, okay, should I pursue this application? Should I not pursue these applications? So that's why the CAIIB in the CAIIB regulation. Sorry. Yeah. So that's why in the CAIIB regulations under regulation 38, there has been a new provision provided where it says that there has to be a detailing as to how the avoidance transactions shall be dealt with. If you see here on the screen, the section regulation 38(2)D provides that a resolution plan shall provide for the manner in which proceeding in respects of avoidance transactions will be pursued after the approval of resolution plan, and the manner in which proceeds, if any, from such proceedings shall be distributed. So now it is a mandatory provision under for any resolution applicant to include in the resolution plan as to how the resolution plan will deal with the transactions with respect to fraudulent or wrongful trading. That is with respect to this resolution plan. Okay. Now, coming back to section 26 and reading it with this, what it implies is that ideally the plan itself will answer how these avoidance transactions will be perused. But coming to the role of the insolvency professional, so now till the time the plan is approved, it makes sense for the RP to continue litigating because the RP is in complete charge. The RP had filed, gone through the transactions and filed the application well and good. But subsequent to the applications being, plan being approved, what the RP or the powers of the RP gets completely suspended and the entire control will be shifted back to the board of directors, or I would say the new board or the new resolution applicant upon implementation of the plan. So at that juncture, can the RP still litigate this is one question which comes forward. So usual practice is that the RP's name will be substituted by the name of the CD or substituted by the RA, and the RA or the CD will continue litigating this particular case. The reason being that the RP will no longer be associated with this company and will no longer be drawing any professional fee with respect to what he does. So it does not make sense for the RP to continue litigating this case perennially till the time the plan is approved. Sorry, till the time the application is allowed. So it will usually the RA will decide this as to how this has to be dealt with. And if at all the RP is supposed to continue doing this, then there may be some professional understanding between the RP and the RA, and accordance which the RP will continue. But usually it will not be in the best interest of either the CD or the COC, because the RP will not have any locus standi at that particular point in time, right? And therefore it may not be appropriate for the RP to continue litigating it. But yeah, technically how to deal with the avoidance transactions, it will be, as I was explaining, it will be dealt with in the resolution plan. So it will accordingly be proceeded for. So this is one other provision of section 26, which is quite relevant to be understood in the context of a avoidance transaction. And finally, before we conclude the session, what are the various expectations of stakeholders from the insolvency professionals with respect to avoidance transactions is that first and foremost is with respect to tracing an avoidance transaction. Now, generally we see that the books of accounts which are provided by the company are usually not in a good shape, be it in tally, be it, even in balance sheets which are being provided. Usually it takes a lot of time for the RPs to compile that information and conclude on the transaction. So ideal expectation from the COC members usually will be to not to delay filing of these avoidance transactions. But if you see the statistically, in every case, there is a delay for filing of the application beyond 135 days for the simple reason of lack of complete information. So the transaction auditors need a hell lot of information, while the information available with the RP is not much. The information available with the RP is usually quite limited, which is restricting the RPs or the transaction auditors in concluding their opinions, and therefore additional time is being provided for. Second, the cost involved in litigating avoidance applications. Now, see, avoidance applications are quite technical in nature. So, though, of course, any advocate, or the practice is something which is similar for any advocate. But ultimately, when it comes to avoidance transactions, there is a need for an expertise on understanding even the financial side of it, not just the legal angle of the transaction, but even understanding the financial side of it is of some importance because of the kind of questions which are expected from the NCLT. So it is important that the insolvency professional chooses a wise, insolvency professional wisely chooses a applicant or wisely chooses a resolution professional chooses an advocate who can better defend the case before the NCLT. And next, with respect to avoidance, what is expected from the RPs is that recovery. So the creditors will be interested to understand that the RP files an appropriate application, which can ensure certain additional recovery back to the assets of the company. So in an event where there is an avoidance transaction, the COC will be interested to see to it that the RP is able to make a good case before NCLT to get the money back from the promoter into the company. So this is always a usual expectation from the RPs, from the insolvency professionals, when it comes to filing COC with respect to recovery and additional recovery which can happen to the COC. Now, beyond this, from the regulator side, what can be the expectation from the IPs is transparency. Now, these avoidance transactions involve transactions where the promoters are personally involved. So the IBBI or the IPA will be pretty much interested to see to it that the RPs are not compromised, or the integrity of the insolvency professionals is not compromised in order to protect such promoters of the company. So where a transaction is abundantly, of course, the law is not intended to even trouble the promoters, but at the same time, where a transaction is clear and clear in the sense that it is justified from the point of view of the RP, that yes, there is an avoidance transaction, the RP should not at any situation avoid it, even from the practical point of view, thinking that the promoters may not defend it, or the promoters have a big law force, they may defend it, or all that stuff is something which is irrelevant for the RP. So the IP shall file the application is what the law says, and it has to be filed irrespective of what opinions the RP has on the promoter. So these are certain expectations which various stakeholders have on the IPs with respect to avoidance transactions. So with this, I conclude my discussion on the avoidance transactions per se, and the roles and responsibilities of the RP, filing of an application, and the RP or the liquidator who will be able to find these transactions. And if the applications are pending after conclusion of CAIRP, what will happen, and what are the various expectations from the insolvency professionals, from stakeholders, is also something which has been adequately captured. So I will open the floor for further questions or deliberations. But if the audience has no further questions or deliberations, then we can conclude the session.
Participants, any questions?
Yeah, Anjali ji, I don't think there are any questions.
Sir, you are requested to share your PPT, please.
Sure, Anjali ji, I'll do that. I'll do that, Anjali ji.
Yes, sir.
Yeah.
Participants, any questions from your side? Sir, I think there are no questions.
Yeah.
So, shall we conclude?
Yes, ma'am. We can come to the session. Yes.
Okay, thank you very much, sir, for such a wonderful presentation. And all the participants, thank you very much to join the session.
Yes, ma'am. Thank you so much, ma'am.
Thank you very much.
Thank you, sir.